ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹಾ ಏನಿಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಫಾರ್ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ 7473/22 ಇದು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ರಿಪಿಟಿಷನ್ ಹಚ್ಚಿದ್ದಾರೆ. ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈಂಟ್ ಇದೆ. ಮತ್ತೇನು ಅಬ್ಜೆಕ್ಷನ್ ಸ್ವಲ್ಪ ನೋಡಿ ಹೇಳ್ತೀರಾ ಪ್ಲೀಸ್?
ನೋಡ್ತೀನಿ ಸರ್, ನೋಡ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಹಲೋ, ಸಾರಿ ಮೇಡಮ್. ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿಲ್ಲಂತೆ, ಅದು ಒಂದೇ ಅಲ್ವಾ? ಅಯ್ಯೋ, ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಆಫ್ ಡೇ ಐ ವಿಲ್ ಇನ್ಫಾರ್ಮ್. ಓಕೆ,
ಕಾಣಿಸುತ್ತಾ ನಿಮ್ಗೆ ಏನಾದ್ರು? ಇಲ್ಲ ಓದ್ಲಾ?
ಓದ್ಬಿಟ್ಟಿ ಮೇಡಮ್ ಪ್ಲೀಸ್.
ಕೋರ್ಟ್ ಫೀಸ್ ಟು ಬಿ ಪೇಯ್ಡ್, ಆಮೇಲೆ ಕಾಪಿ ಟು ಬಿ ಸರ್ವ್ ಟು ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್, ಕಾಪಿ ಟು ಬಿ ಸರ್ವ್ ಟು ಕೇವಿಯೇಟರ್.
ಸರ್ವ್ ಮಾಡಿದೆ ಕಾಪಿ.
ಅದಲ್ಲ, ಅದೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರೋದು. ನೀವು ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಏನು ಹಾಕ್ಲಿಲ್ವೇನೋ ಅಂತ ಅನ್ಸುತ್ತೆ ನೋಡಿ.
ಓಕೆ, ಕೋರ್ಟ್ ಫೀ ಟು ಬಿ ಪೇಡ್ ಅಂತ. ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಕೊಟ್ಟಿ ಕಟ್ಟಿಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ನಲ್ಲಿ 21 ಕೊಟ್ಟಿ ಕಟ್ಟಿಲ್ಲ ಆಮೇಲೆ ಗವರ್ನಮೆಂಟ್ ಕೊಂಡು ಗವರ್ನಮೆಂಟ್ ಪಾಲಿಸಿ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಹೋಗಿ ಆಫೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಕಂಪ್ಲೈಂಟ್ ಅಂತ ಹೇಳಿ ಇದು ಸರ್ವ್ ಮಾಡ್ತೀವಿ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ₹100 ಕಟ್ಟಿಬಿಡಿ ಮಾಡಿ ಆಮೇಲೆ ಗೌರ್ಮೆಂಟ್ ಒಂದು ಕಾಪಿ ಕೊಡ್ತೀವಿ ಆಯ್ತಾ
ಸರ್ ಹೇಳಿ.
ಹಲೋ,
Malaj,
Yes. ಅದೆಲ್ಲ day after tomorrow. Day after tomorrow wait for you. ಇನ್ನ ಶಿಫ್ಟ್ ಆಗಿಲ್ವಾ ಬ್ರಾಂಚ್?
Malaj and humble submission, Malaj.
Yes, we are calling out by page, then you could make your submission. ಅಲ್ಲಿ ಇನ್ನೊಂದು ವಾರ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗುತ್ತೆ because the branch is being shifted. So it won't be listed until the files are found. ನೀವು ಇನ್ನೊಂದು 4 ಮೆಮೊ ಕೊಟ್ಟರೇನು ಅಷ್ಟೇ ಆಗುತ್ತೆ. ಸ್ವಲ್ಪ ಒಂದು ವಾರ ವೇಟ್ ಮಾಡಿ. Wait till they shift the branch and they set the files. ಸಿಗಲ್ಲ files.
Malaj, serial number 14, Malaj.
They inform the respondent. 29, counsel for the petitioner submits submits that the arguing counsel is unwell and as such a week's time is sought for released on 25th.
My lord, serial number 14, my lord.
Has it been called out, Mr. Shravan?
My lord?
Has that matter been called out?
No, my lord.
Then why are you mentioning?
I apologize.
ಯಾರ್ದು ನೀವು ಹೇಳಿದ್ರೆ ಅವ್ರು ಏನ್ ಕೇಳಿಸಿಲ್ಲ ಇವಾಗ ಹೇಳಿ. 23, 24. 23, 24, 34, 37, 40. Jennifer HR is stated to be unwell and is released on 13/9. 40 yearly interim order is extended to next week. 25 ಬರಲ್ಲ ಫಸ್ಟ್ ವೀಕ್ ಆದ್ಮೇಲೆ ಬರೋದು ಅಂತ ಹೇಳಿ 13, 6 ಮೊನ್ನೆ ತಾನೇ ಅಷ್ಟೊಂದು ಹಾಕಿದ್ವಿ ಅವ್ರದ್ದು 13th ತಗೊಳ್ಳೋಣ 13th of September. ಏನ್ ಕೌನ್ಸಿಲ್ ಬರ್ಬೇಕಲ್ಲ ನಾಟ್ ವೆಲ್ ಅಂದ್ಮೇಲೆ ಯು ಶುಡ್ ನಾಟ್ ಇನ್ಸಿಸ್ಟ್. 37 released on 6. ಬಾಕಿ ಎಲ್ಲ 13. Have you informed Mr. Naik? Have you informed Mr. Naik? Will inform ಬೇಡ Mr. Inform ಮಾಡಿ. At the request of the RS is the released on 1st September. Yes. You are appearing for whom? Have you informed the petitioner? Will bada. Wait. Next.
Page number 9. Page number 42. Page 10. Page number 46 to 49.
Have you informed the response? 43 as a request to the council for the petitioner released on 1st September.
Page number 7. Page number 15.
Okay.
Order page number 1.
So if the interim order would have been extended till next year, so whenever it is taken up next year, it will be taken up. What is the urgency, Mr. Council? If there is an interim order, it's been adjourned, extended till next date, alva. ಮತ್ತೆ ಬಿಡಿ ಬರುತ್ತೆ. It will come up. Oh. Better.
Page number 1. Government advocate.
ಯಾರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೀರಾ? What about all these IAs? ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ? ನೋಟಿಸ್ ಹೋಗೋದು ಬೇಡವಾ?
CF not.
Yes, not. Notice was ordered on 4/1/2022 and you still haven't paid the PF. So dismissed. Conditional order was passed on 28/7, still you are not paid. Recall application after. Despite the order dated 28/7/2022, the process fee has not been paid by the state. It is rather unfortunate that the state has not paid process fee for the last 7 months. Hence, IA 1/21 to 18/21 are dismissed for non-prosecution. April done. Awaiting service on 8 hours. Processing output. Notice to respond has been dispatched on 8th August, awaiting service, released on 13th September. Yes, ಕೊಟ್ಟಿದ್ದೀರಾ? ಯಾವತ್ತು? When a GS or AGS submit that the procedure has been paid on 11th. That is so. Registry is directed to issue notice to respondents returnable by 20th September, released on 20th September. Four. Yes. Notice to respond has been dispatched on 12th August, awaiting service, released on 20th September, interim order earlier granted is extended in the
Serial number 7 will.
Not 7, 5.
Sorry.
Notice to respond has been dispatched on 12th August, awaiting service, released on 20th September. Counsel for the petitioner seeks to and is granted a week's time. If needful is not done by 23rd, the petition will be liable to be dismissed for non-prosecution, released on 25th. Yes,
I am appearing for the petitioner, my lord. I have served a copy of the caveat to the respondent advocate, and so far as I will do that during the course of the day, my lord. Other they have to pay.
Passover, ಮಾಡ್ಬಿಟ್ಟು ಹೇಳಿ.
I will pass.
Yes, ready? Payment ಮಾಡಿಲ್ವಾ madam? You don't want to file objections to the writ petition, ಹೇಳಿದ್ರಿ. You are ಮಾಡಿ. Ready na? Passover. ಬೀಚ್ ಅದ ನೋಡ್ಬೇಕು ನೀವು ಅವ್ರ ಮಧ್ಯಾಹ್ನ ಅಡ್ಮಿಟ್ ಅಂತಾರೆ. Counsel for the petitioner is ready to address arguments. Counsel for the respondent seeks for a Passover. However, the counsel for the petitioner expresses personal inconvenience in the afternoon today. Released on 25th. 25th ತಾರೀಕು at 2:30 p.m.
Serial number 9, I am for respondent.
Yes, Mr. Murthy, who is taking notice? You are taking notice on IA.
He said there's an order.
ನೀವಿಬ್ರು ಒಂದೇ ತಾನೆ ಅವ್ರು ಹೇಳಿದ್ ನೀವು ಕೇಳಲೇಬೇಕು ಅಷ್ಟೇ. This also accepts notice for the impleading applicant.
The lordship that I had submitted that I have no objection for impleading. And also for filing documents also had no objection.
ಇವಾಗ ಅವ್ರಿಗೆ ಒಂದು ವಾರ ಕೊಡೋಣ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಂಡ್ಬಿಟ್ಟು we'll hear the matter.
ಯಾಕೆಂದ್ರೆ it is already
now Mr. Murthy has got his friend here, so your time is saved by that much.
Like your lordship, after hearing, they may be ordered to amend the.
Correct. ಇವತ್ತೇ ಮಾಡ್ತೀವಿ ಅದು. I have also accept notice for impleading for the proposed respondent in all the matters. Shri P.S. Anantram, the council submit that he has no objection for allowing the impeding applications. Hence, impeding applications are number not only. He is allowed counsel for the petitioner to carry out necessary amendment and file amended petition. He so and so seeks for and is granted a week's time to file his objections to the main. Objection is to be filed on or before 23rd August after serving a copy thereof on the counsel for the petitioner and counsel for respondent number 1. Released on 25th at 2:30 p.m. Serial number 9 IA1 of 2022 has been filed for production of certain additional documents. T.S. Anantram, counsel for respondent, submit that he has no objection for allowing the said application. As such, IA1 of 2022 is allowed. The documents produced along with IA1 of 2022 is taken on record.
And they may be ordered to serve the copies of documents to me because they
Copy
have
ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ documents?
copy ಕೊಟ್ಟಿಲ್ಲ.
Copy ಕೊಟ್ಟಿದ್ದು ನೀವು objection, no objection ಅಂದ್ಬಿಟ್ರೆ
ಅಲ್ಲ because
ಏನಿದೆಯೋ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ subsequent documents I am telling you, if they
IA1 of 2022 ಅಲ್ಲ, 1 of 2022 ಕೊಟ್ಟಿದ್ದೀರಾ? ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
I have received no.
Yes.
EA is filed by me. Order of termination of contract is there before. There was a direction for installation. Now we are there is an optional stay of the award. No, it's not coming to like EA is filed by me. Award was 2000.
17B and objections.
EA objection was. The objection was.
ಏನು objections? Then argue the matter. 17B ಎಲ್ಲಿ ನೀವು ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿದ್ರೆ ಹೆಂಗಾಗತ್ತೆ?
Certification has to be not only the object of
After 10 years.
This court consistent because to review. There is 17B application filed without studying the merits of court and the idea of the court of. The very short judgment that has been out by the Supreme Court also. Several cases.
ಫಸ್ಟ್ ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಬೇಕು ಅಂತಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 17B ಮೇಲೆ. Mr. Chair, Mukunappa, this does not say that it cannot be taken up together. It only says 17B to the expedition. If we are going to take up the entire matter on merits. We are disposing the entire matter today. What is the matter dispose ಮಾಡಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ? Okay, I considered rejected. Now here on the merits. I considered rejected here on merits. Mr. Mukunappa, we understand. But instead of doing this, if both of you are ready, take up on merits and dispose of the matter. All the produce matter, when judgment produce matter. Learned counsel for the learned AGA submit that he is ready for addressing arguments on merits. Sri Mukranappa, learned counsel for respondent submits that first the application under 17B, namely IA1 of 2022, is to be taken up for consideration, and only thereafter the matter could be taken up on merits. We submit that this being the position of law, you would place certain decisions on record. This court has clearly stated that the matter could be taken up on both the IA and the main if both the counsels are ready. Released on 25th at 2:30 p.m. If we are going to adjourn it, we understand. If you are going to take up both together, what's your problem? Well, 2020, 17, 16 matters. So, ಇದುವರೆಗೂ ಆಗಿಲ್ಲ ತಾನೆ. ಇವತ್ತು we are ready to take it up on merits. You don't want the merits to be taken up. ಎರಡು ಒಟ್ಟಿಗೆ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ ಏನಂತೆ. The matter could be disposed of. You don't want the matter to be disposed of. Now, whichever matter reaches Mr. Mukranappa, we'll take it up. If you want to argue the matter, please argue the matter, we'll take it up. We are not adjourning any matters unless the council asks. If you are ready, we'll take it up. ಅಷ್ಟೇ ನೀವು ರೆಡಿ ಅಂದ್ರೆ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ ದಿಸ್ ವೇ ಆರ್ ದಟ್ ವೇ ಅಷ್ಟೇ. ಅದಕ್ಕೋಸ್ಕರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಏನು ಇದ್ರ ಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಅದರ ಮೇಲೆ ಒಂದು 25th ನೋಡಿ ಅದೇ these are all old matters which are pending. You should dispose it. Geeta Shinde.
My lord, I appear for the respondent, my lord, in
Yes.
serial number 11.
Yes.
My lord, in the last occasion, the Honorable Court directed me to file the objection, my lord. However, my lord, the respondent is a widow and she was not available to verify the contents of the objection, my lord. I request the Honorable Court to consider the IA itself as an objection to the writ petition, my lord.
Learned counsel for respondent submits that she does not intend to file separate objections for the writ petition, but the IA number 1 of 2022 may be considered as objection to the main. Learned counsel for the
Please,
petitioner seeks for and is granted a week's time to get ready and address his arguments. Released on 25th.
Obliged.
25th, ಬೇಡ. First September. What is the correction, man? OS number 7664 ಅಂತಿದೆ. ಏನಂತ ಕರೆಕ್ಟ್ ನಂಬರ್? But where is that mentioned in the petition? Make sure F 2458. What is this number of 7664? Seven 664 was filed by the dependent. Yes, Mr. Gopal. The application was filed on 24th June. At 9660. ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? 1048 ನೀವು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? 9660 ನೀವು ಅಪೇರ್ ಆಗ್ತಾ ಇಲ್ಲ. Now the only issue is that there is a typographical error of 7660 to 2458 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಫೈಲ್ ಒಂದ್ಸರಿ ತೋರಿಸಿ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ ನೋಡಿ. ಯು ಬಿ ಸ್ಯಾಟಿಸ್ಫೈಡ್. ಆಮೇಲೆ ಇನ್ನೊಂದೇನು ಕರೆಕ್ಷನ್? Because now 4 weeks have already lapsed. ಅದು next 2:30 ಬನ್ನಿ. 2 ನಿಮಿಷ ಆಗ್ತದೆ. Mr. Rosario has entered appearance for the respondent. His memo of retirement filed by Shri A.J. Srinivasan is accepted. He is permitted to retire from the matter. He is discharged from the matter. Yes. Yes, you are appearing? What about you, madam? But are you ready for arguments? Both the councils seek for and are granted 10 days time, released on 1/9. Yes, Mr. Madhav.
Malaj, I'm appearing for respondent number 4 and serial number 14, Malaj. Malaj, I seek a short adjournment, Malaj, in this matter. For respondent number 4, Malaj, in serial number 14.
No, last time a specific date was fixed for you to get ready and address.
Malaj, there's a personal inconvenience, Malaj. Short date, maybe.
They want adjournment. How much contribution to the advocate's library fund?
Malaj?
How much contribution to the advocate library fund will you make?
Malaj, there's seriously a personal inconvenience today, Malaj.
The counsel for respondent submit that he has some personal inconvenience today to address arguments. We list on 1/9, it is made clear that no further adjournment will be granted.
Much obliged.
Interim order earlier granted is extended till next year. Counsel for the petitioner files objections to IA-1 of 2022 after serving the same on the counsel for the respondent. The same is taken on record. तुमने ready ना? Rejoined रखा. Subramanian or rejoined or argument or rejoined? 20, right? K. Subramanian has filed a memo along with citation after serving a copy thereof on the counsel for the petitioner. The same is taken on record. The counsel for the petitioner seeks for and is granted 1 week's time to get ready and address arguments released on 1/9. First September. Mr. Naik, you are appearing.
My lord, appear for the respondent in serial number 16.
Who is the impleading applicant? Who are you? IA 1 of 2022 has been filed to bring on record the unions who had participated in the CJIT proceedings. The Land Council for the petition has no objection for the same to be allowed. Since IA 1 of 2022 is allowed, the persons named therein are brought on record as respondent number 2 to 4. Council for the petitioner to carry out necessary amendment and file amended cost factor. The council for the impleaded the respondent number 2 to 4. 6 fund is granted 10 days time to file a statement of objection. Objection is any by 2/9, relist on 8/9. Interim order earlier granted is extended to next week. What about you, Mr. Bannett? Do you have filed your objections?
3 weeks. I seek 3 weeks time to file objections, my lord. So
3 weeks.
Yes. Day before yesterday, I've received the file.
3 weeks. The council for respondent also seeks, respondent number 1 also seeks for 3 weeks time to file a statement of objection. Objections, if any, to be filed on or before 12th September, relist on 15th September. Interim order earlier granted is extended to next week. Yeah. Any objections? Serious. Let Mr. Manmohan start. If you are serious, if you don't have serious dispute, we could appoint. Let Mr. Manmohan, you can start. Petitioner?
Meanwhile, what the respondent did was stop not the issue of services in the practice agreement. On the ground that payment was 58. So the payment of maybe policy for the last November. So direct meeting we made to call on pending payment for head of license.
Yes.
This is a different contract. Since there is no process of taking the due. Ask your artist to stop supporting your team for oracle service. But they themselves club not both the agreement. And not stop not abruptly. We not transfer knowledge, but everything was came to complete standstill for us. But they club these two services. Saying that you are not fit for head of license. They will stop oracle.
Okay.
But in this background, but we should notice to them. Page 59 was our reply. We said the two separate contracts. But you all think that together in your stuff to services now. Then what we issue the legal order of page 16. Say that I have to not to see 1 crore 55 lakhs. So I thought the appointment now. But they have not responded to this. But still not the.
So what is the dispute that you wanted to refer in this? What is the dispute that you wanted to refer to the arbitration in this notice?
This notice is what to turn to page 64. Also refer to the fact that suddenly stop services. Para 8 would have referred to what they have claimed with regard to what the hello license issue. Para 12 has said you suddenly stop.
So you have claimed damages.
It has to be damages.
For not being able to use Oracle services.
Yes, one issue was what was Para 14. But the implementation of Oracle ERP was handled by them. We could work for database and other back end operations for the following modules: order management, pricing, account refusing, account payment. Then we start with team. So we were unable to access our files because they stopped services on the ground that the other payment is not free.
So for that you want to seek for damages. So now the issue that you want to refer to arbitration is the damages on account of Oracle services being dropped. What about Adobe?
Now they say about but that is no doubt not to back about the fact remains that they have plugged both the times. They have now said that as I pointed out in the email, because you have not paid for that contract, I am stopping for another contract.
Now where is the Adobe agreement and where is the Oracle agreement?
The other agreement is the same.
33. This is form 30. Wait.
Start at page 18.
18.
Arbitration process at page 28.
So 18 will promote technical issues and review by the deputing technical person. Service request 12 months. Where is the arbitration clause?
Page 28. Dot two. Bottom of page. Language will be partial complicated reference to resolve all
What happened to that resolution of misunderstanding?
But we have written to them, but ultimately not received the email that they have sent us.
Had you called upon to come and discuss with you?
But we have written to them, taken
Where is that?
page 42.
Mutual discussion. So they did not come forward for mutual discussion.
But they did not, in fact, not their own not made, they found it out in page 58. But they have themselves referred not that they have had got the direct meeting, etc. May call for pending payment of below. If there is no further section, the group is asking to stop the whole thing.
Yes.
Number at page 43. And the reply not to the demand notice in the form 3. Then at page 45, I have pointed out that because of this office of service, currently with reference to Oracle support.
So you want to refer the dispute of stopping the Oracle support in terms of Annexure A.
Yes.
You are not referring any dispute as regards Adobe.
I want to say because of their own conduct, they themselves have clubbed not both these issues together. But insofar as not
The dispute is only as regards stoppage of Oracle services.
insofar as not my claim is concerned. But even for some of the 1.5.
Adobe, if they have any claim, they should initiate proceedings for recovery.
But they have not both these transactions together. Which is evident from their own name. But what if, in fact, earlier when I pointed, these both companies putting together. Because they separate contract, but they say nothing doing, you are not paying me for a road.
One more, if they have initiated action against Adobe by issuing IBC notice, it is for you to defend it there by invoking the arbitration clause or otherwise. Your notice here is only as regards Oracle services. But what's your claim going to be on Adobe? If you are the claimant. You can claim a set off if you are the defendant, not as a plaintiff. He has not come forward, Mr.
He
Manmohan.
not come forward. At the moment in the reply, two wrote form to the entire thing was the same. You can get the set up.
That you do it before the NCLT, not here.
But the result that people.
NCLT is different.
They themselves have got these issues together.
There is no claim made by them on record today, Mr. Manmohan. In a CMT, they haven't come before this court. We can't exercise jurisdiction on that. There's only a section 11 jurisdiction.
Yes. Other than saying it's money, there is overlap in the parties are the same. Go down this to agreement, but I'm not.
That you go file your section 8 application, see what happens, and then we'll see. Unless you consent to both the matters to be referred to arbitration. You don't consent. But Oracle, you have to refer.
They have issued a notice for recovery from raised to Oracle. In fact, under the Oracle district, they did not clear our invoice.
Adobe they did not clear or Oracle they did not? Both they went.
So Adobe gets separate initiated proceedings for the SPL. Thereafter, they have issued a notice saying there is a dispute in relation to Oracle as well. We want to club both matters. I agree that there is an email on record, but we have not acted on that email. In fact, it was because under the Oracle agreement. So the
Anyway, you will not come before us to refer any matter. So, yes. Petitioner is before this court seeking for the following relief. The petitioner claims to be a newspaper publishing company who had entered into two separate agreements with the respondent for providing software solutions and services. Under one of the agreements, the respondent was required to provide Adobe licensing, ADOBE, Adobe licensing and services. And under another agreement dated 33/2020, the respondent was required to provide Oracle database support. Alleging that the petitioner has not made payment of the due amount towards Adobe licenses, the respondent, via this email dated 29 January 2021, stopped support for Oracle database services. And within that background, that the petitioner had issued a notice dated 7th November 2021. Within that background, that the petitioner had called upon the respondent to resolve the matter disputes amicably, which did not resolve. And as such, the petitioner had invoked the arbitration clause under the work order dated 33/2022. 33/2020. More particularly, clause U thereof, which is reproduced hereunder for easy reference, page 28. The petitioner, by the notice dated 7th November 2021, had provided a panel of 3 arbitrators for the respondent to choose from to arbitrate the disputes. However, the same was not acceptable. The same was not concurred with by the respondent, and after the petitioner is before this court. Shri P.N. Manmohan, learned counsel appearing for the petitioner, would submit that it is on account of the services relating to the Oracle database management and services not being provided that the petitioner has incurred several losses and damages, which are the cost for the notice dated 7th November 2021. And as such, this dispute is required to be referred to arbitration. He further submits that as regards the alleged Adobe license dues, the respondent initiated proceedings under the Insolvency and Bankruptcy Court, now pending before the NCLT, which also could not be done, and as such, both the disputes are required to be referred to arbitration. Per contrast, Sri, what's your name? Shri Gaurav Madhapa, when a council appearing for a respondent would submit that the petitioner is seeking to club two different contracts and two different arbitration clauses, which is not permissible, inasmuch as there is a separate agreement relating to Adobe services and a separate agreement, separate work order relating to Oracle database services. The disputes in the legal notice being that as regards Oracle database services, the question of referring the dispute as regards Adobe services, Adobe license fees would not arise. Third, is so on to so on. Third. Admittedly, there are two agreements between the petitioner and the respondent. One for Adobe license, one as regards Adobe licenses, and the other as regards Oracle database services. The services as regards Adobe license has not been suspended. However, there is a claim made by the respondent as regards amounts due under the Adobe agreement. We're not getting into those. We can't express our opinion on merits of the matter. Adobe agreement. Alleging that those amounts were due to services as regards the Oracle database services were suspended. Correct. As regards the license fees used on the Adobe under the Adobe agreement, separate proceedings have been initiated by a respondent under the Insolvency and Bankruptcy Code. Though the contention of Sri Manmohan PN and counsel for the petitioner is that by invoking the dues under the Adobe agreement, like services under the Oracle agreement have been suspended, resulting in losses being caused to the petitioner. The petitioner per se does not have any dispute or a claim insofar as the Adobe agreement is concerned, inasmuch as it is the respondent who has invoked proceedings for recovery of the monies under the IBC. If at all the petitioner is aggrieved by the same, the petitioner would file necessary proceedings under Section 8 of the Arbitration Conciliation Act 1996, seeking for reference of that matter to arbitration. The same not being subject matter of the present matter, this court is not expressing any opinion as regards the Adobe agreement. Correct. As regards the Oracle database services agreement, admittedly there is a dispute between the parties, as regards which notices and replies have been exchanged. Correct. There being a dispute which is required to be resolved in terms of annexure clause U of the work order dated 30th March 2020. I have a considered opinion that the same would have to be resolved by way of arbitration as agreed upon between the parties. In view thereof, I pass the following order. The petition is allowed. Allowed in fact, the matter is referred to Krishna Bhatt, the former judge of this court, is appointed as a sole arbitrator with the consent of both the counsels to arbitrate the dispute between the parties under the aegis of the arbitration center attached to this court. Registry is directed to forward a copy of this order to the Director, Arbitration Center, for doing the needful. All contentions are left with. No, you couldn't do that. You have no claim there. At the most, you are a defendant. What are you filing, Ms. Magda? Third counsel for the petitioner submits that the public interest litigation in WP 17552 of 2021 is still pending, and we seek for the matter to be adjourned by a period of 3 months. Released on 17th October. ಅದ್ರಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ? L. Shekhar, the counsel for the petitioner, submitted the management has also challenge the very same award and the challenge in the present proceedings in WP number.
9179.
Registry is directed to connect both the matters. The SB Shrikant, who has appeared for the management of the said matter, is directed to accept notice for the respondent in the present matter. Counsel for the petitioner to serve a copy of the petition along with annexes on the said counsel. ಏನ್ ಡೇಟ್ ಏನು? ಹಾಗಾದ್ರೆ ಕೊಡಲ್ಲ ಡೇಟ್. Number 10 entry model. Entry model. Yes. Respond number 1. Sri V.S. Nayak, then K-Waiter. Party in person ಅಂತಿದ್ದಾರೆ. ವಕಾಲತ್ ಬಂದಿದ್ಯಾ ಮಿಸ್ಟರ್ ನಾಯಕ್? ಬಂದಿದ್ಯಾ? Sri V.S. Nayak, the counsel, submit that he has received wakalatnama from respondent number 1 who was earlier appearing as a party in person, and that he would be filing the wakalatnama during the course of the day with the registry. That be so, registry is directed to print the name of Sri V.S. Nayak as that appearing for respondent number 1. Copies ella bandidya? ಒಂದು ಮೆಮೊ ಹಾಕ್ಬಿಡಿ, ನಿಮ್ಮ ವಕಾಲತ್ ಬರ್ಲಿ ಮೆಮೊನು ಹಾಕಿ. There is a party in person appearing, you file a memo. Our signature turned at. We list on 23rd.
I appear for petitioner's counsel, my lord.
Mr. Subbarao.
In this case, there was a talk of settlement. It appears, my lord, we may have to argue the case. Your lordship may give a date. We will argue it.
No settlement, Mr. Kasturi?
He wanted, Mr. Kutlaba wanted revised proposal, gave it. I thought they have agreed. Now suddenly they are going back.
No, we never agreed. Please.
He thought you had agreed anta.
He
You
wanted,
agreed and
there is a-
thought you had agreed anta.
I will tell this. I offered 3 lakhs. Then I revised it to 4. He said, why not, Mr. Kutlaba said, why not you make it 5? I said, yes, I am agreeable to talk to clients.
My lord,
Now they don't want to agree to that.
my lord,
ಇವಾಗ Mr. Subbarao ನಿಮ್ದು claim ಎಷ್ಟು?
my lord, what happened was there were 21 cases where, my lord, they paid 8 lakhs to each. These are the 3 cases where they lost. These are 3 cases, my lord, where they want to make a distinction. I said, you pay the same thing where you have paid to those people.
It was not 8 lakhs. For information, my learned friend is wrong.
How much was
Secondly-
paid, Mr. Kasturi?
All right,
Kindly-
whatever you paid to those people, please pay here.
I cannot pay because there is a distinction. That case.
All
I
right,
was at
then we
fault.
will argue.
Court
If there is
found
a
me at
distinction,
fault.
we will
Now
see.
here, for 25 years, they are not reported for work.
Yes.
ನೀವಿಬ್ರು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹಿಂಗ್ ಕೇಳೋದು ಕಷ್ಟ ಆಗತ್ತೆ. ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ಕಸ್ತೂರಿ?
I am prepared to give that 5 lakhs of rupees because this case, I
ಅದ್ರಲ್ಲಿ
will
ಎಷ್ಟು
tell you
ಕೊಟ್ಟಿದ್ದೀರಾ?
also.
ಬಾಕಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
Kindly permit me to say a few words. In those cases, the court held, division bench, that I did not comply with section 33 2B by withdrawing the petition.
Not on merits, we are not on merits.
Merits ಅಲ್ಲ, ಯಾಕೆ distinctions distinction ಯಾಕೆ ಅಂತ ಹೇಳ್ತೀನಿ.
ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಬೇಡ. ಅವ್ರಿಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಮಿಸ್ಟರ್ ರಾವ್.
No, I cannot give the same. Client says, what is the difference? I have not committed any fault.
See, my lord, this is the attitude.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಅಷ್ಟೇ ಮಿಸ್ಟರ್ ಕಸ್ತೂರಿ ಕೊಡಿ ಅಂತ
5
ಹೇಳ್ತಾರೆ.
lakhs each. I am prepared to pay these 3 people.
ಅವ್ರಿಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಬಾಕಿ ಅವ್ರಿಗೆ?
ಅವರಿಗೆ 6 ಕೊಟ್ಟಿದ್ದಾರೆ. 6.5 ಕೊಟ್ಟಿದ್ದಾರೆ.
8 lakhs.
ಇಲ್ಲ ರೀ ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು ಗೊತ್ತಿಲ್ಲ ರೀ.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಆ dispute solve
ಬಿಟ್ಟಿದ್ದೀರಾ
ಮಾಡೋಣ.
ಎಲ್ಲ.
ಮಿಸ್ಕಮ್ಯುನಿಕೇಶನ್ ಫಸ್ಟ್ ಕಮ್ಯುನಿಕೇಶನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಣ. ಅದರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಅದು ಕ್ಲಾರಿಟಿ ಬರ್ಲಿ ಫಸ್ಟ್.
It was about 7 lakhs or so, my lord. 6 lakhs ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. ಅದು ಕೊಟ್ಟಿದ್ವಿ ಆ ಕೇಸಲ್ಲಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನಕ ಹೋಯಿತು. ಇಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ಡ್. We were 6 lakhs we paid. ಅಂದ್ರೆ ನಾವು ಹೋಗಿಲ್ಲ, ಅವ್ರು ಹೋಗಿದ್ರು.
ಅಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರೆ 6 lakhs.
ಇಲ್ಲ. The difference is my client is asking one question. There I was at fault. Sorry, my lord.
If you have paid 6 lakhs, then we are telling Mr. Subbarao
I will,
5 lakhs.
my lord, my lord, I will show him the order, my lord, where he has paid how much. There is a court order.
This
There
is
is
court order of Justice Chavan.
ನೀವು ಹಂಗೆ ಇಟ್ಕೊಂಡ್ರೆ ಕಾಣಿಸಲ್ಲ.
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ ಕೈನಲ್ಲಿ. ಅವ್ರು ಏನೋ ಯಾರೋ ಹೇಳಿದ್ದಾರೆ 8 lakhs ಅಂತ ಅವ್ರಿಗೆ ನೆನಪು ಬಂದು ಈ
Since both of you are there, we thought if you come so close, let us make you meet anta.
He is very far, my lord.
I am not firm.
Mr. Subbarao cannot be easily satisfied with any amount.
Yes. Subbarao is a common man. He is a very old man. He is not, he requires only 2 morsels of food. That's all.
ಒಳ್ಳೆ ಕಮ್ಯುನಿಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಏನ್ ಮಾಡೋದು ಸುಬ್ಬರಾವ್? Difference is now between that 5 and 6. You want to argue the matter?
My lord, we will do one thing, my lord. I will talk to him. I will show him how much, and we will be able to. Other, your lordship may give 3 weeks time, and if it is not possible, we will argue, my lord.
25 years ಕೆಲ್ಸಕ್ಕೆ ಹೋಗಿಲ್ಲ ಅವರು ಟ್ರಾನ್ಸ್ಫರ್.
ಹೌದಪ್ಪ, ವರ್ಕರ್ಸ್ ಎಲ್ಲ ಹಾಗೆ ಏನ್ ಮಾಡೋದು?
ಕರೆಕ್ಟ್.
ಸ್ವಲ್ಪ ಏನಾದ್ರು ಮಾಡಿ ಅಂತ ಮಿಸ್ಟರ್ ಸುಬ್ಬರಾವ್.
ಹೌದೌದು.
Both the councils submit that if given 3 weeks time, they will try and explore the possibility of settlement or else go on with the arguments on the matter.
Yes, my lord.
We list on 14/9 for either reporting settlement or going on with arguments.
21/9, my lord.
14th.
ಎಷ್ಟಂತೆ? 14. Much obliged.
3 weeks ಅಂದ್ರಲ್ಲ.
ಹೌದು.
14 ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್.
Otherwise, my lord, we will take the.
ಅಷ್ಟೇ.
Yes. We will take the court's order.
Now the difference is between 5 and 6. You decide.
Yes. My lord, I am, my lord, what can be done? These managements have become East India companies. That's the problem.
We were a East India company only. Become ಏನಿಲ್ಲ.
14th Wednesday. Sorry, 15th, Mr. Rao. Mr. Kasturi, 15th.
Very well.
15th.
Next is today. Next 28 ಅಲ್ವಾ?
My lord, I am appearing for the respondent 1, 2, 3, my lord. Kindly grant 2 weeks time, my lord, because Puttagoda sir is not keeping well. He is went to hospital, my lord. It may be taken next week, my lord. Any date may be fixed, my lord.
Right, 1 minute. To allot work with retrospective effect ಎಲ್ಲ ಕೇಳಿದ್ದೀರಾ? It's submitted that the council for respondent number 1 and 2 is unwell and as such adjournment is sought for. Released on 1/9, 1st September, madam.
Much obliged.
25.
My lord, appearing for petitioner, my lord, in this.
Yes.
My lord, I'm for the Gram Panchayati, my lord, Kartikara Gram Panchayati. My lord, the matter pertains to Minimum Wages Act, my lord, under the claim petition filed by the respondent, my lord, under section 20. The
21. I heard you, Mr. Uncle.
Yes, my lord. My lord, the respondent, my lord, the third respondent was working as a waterman, my lord. Waterman in the Gram Panchayat since 2006 to 2011, my lord. My lord, on 4/4/2011, my lord, he resigned from the job. I mean, he resigned means it is not a permanent job, my lord. It's only a part-time job. Every day he used to work for 1 hour, my lord. My lord, on 4/4/2011, he stopped coming to the work, my lord. And on 14/3/2012, my lord, he filed an application, my lord, claim petition under section 20 subclass 2 of Minimum Wages Act, my lord, before Honorable second respondent, my lord.
Yeah, when did he stop coming?
4/4/2011, my lord.
4/4/2011.
Yeah, my lord.
Yes.
He filed a claim petition, my lord, on 14/3/2012, my lord. My lord, the claim petition was filed under section 20 subclass 2, my lord, of Minimum Wages Act, and the said petition came to be allowed, my lord, and the petitioner was directed to pay 1,97,042 rupees, my lord. My lord, my contention before this honorable court is that, my lord, as per Minimum Wages Act, my lord, he doesn't come under the section purview of employee-employer relationship is not there in this petition because, my lord, at the time of filing this petition, my lord, the first respondent was no more working in under the petitioner, my lord, petitioner Gram Panchayat.
He is
First ground, my
claiming
lord.
for the period that he was working, not continuous
Yes,
payment. Allah.
yeah, and then, my lord, this. Yeah, as per the judgments, my lord, filed passed by this honorable court and also by the Supreme Court, my lord, honorable Supreme Court, for any the Minimum Wages Act section 20, the claim petition can be filed only seeking to fix a minimum wages, my lord. But in this case, the government has fixed a minimum wages, but for payment of arrears, my lord, he ought to have filed application under section 15 subclass 1 of Payment of Wages Act or section 33(3) subclass 2 of Industrial Dispute Act 1947, my lord.
Minimum wages.
And my lord, this honorable court heard in writ petition number
ನೀವು
4,
petition number ಅಂತ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ ಮತ್ತೆ ಓಂಕಾರ, you have to give us copies.
yes, my lord, I last time I had given, my lord, because I had some injury in my leg, so I could not come.
ಕೊಟ್ಟಿದ್ರೆ we'll see if it is there.
Last time it was partly heard, my lord. I heard in a length, at length, my lord.
WB
On
number
one clarification.
45891.
Yes, my lord. Yes, my lord. 2013.
45891 of 2013. What para do you want to refer to?
13. 1 minute. My lord, para 6. Para 5, 6, 7, my lord. And at length it is discussed, my lord, and page number 7, my lord, I may be permitted to read, my lord. Instead of reading all this, my lord, the only relevant portion I will read, my lord. Page number 7, my lord. The power to make orders for payment of actual amount due to an employee under section 20 subclause 3 cannot therefore be introspected as indicating that the jurisdiction to the authority under section 20 subclass 1 has been given for the purpose of enforcement of payment of amounts and not for the purpose of ensuring compliance by the employer with the various rates fixed under that act. This interpretation, in our opinion, also harmonizes the provisions of the Minimum Wages Act with the provisions of the Payment of Wages Act, with the which was already in existence when the Minimum Wages Act was passed. In the present appeals, therefore, we have to see whether the claims which were made by the workmen in the various applications under section 33C subclass 2 of the Act were of such a nature that they could have been brought before the authority under section 20 subclass 1 of the Minimum Wages Act, inasmuch as the rise disputes relating to the rates for payment of overtime and for work done in weekly off days. It is thus clear that where there is no dispute as to the rate of minimum wages employee, and if it is only for the enforcement of the balance of wages due, section 20 subclass 1 has no application. The Honorable Supreme Court has held that the petitioner has other remedies for the enforcement under section 15(1) of the Payment of Wages Act 1948 or section 33(c)(2) of the Industrial Dispute Act 1947. Therefore, the application filed by the first respondent or the annexure B not maintainable. I am of the view that the order passed by the second respondent dated 26/8/2012 at annexure A is without jurisdiction. It is accordingly quashed. However, liberty is reserved to the first respondent to approach the competent authority for redressal of his grievance in relation to the payment of the minimum wages under section 15(1) of the Minimum Wages Act 1948 or under section 33(c)(2) of the Industrial Dispute Act 1947. Therefore, before the competent authority, in such an application is made by the first respondent within 6 months from the date of the receipt of the copy of the order, the authority concerned is directed to receive the same without raising objection as to limitation and consider the matter in accordance with law. No cost. My lord, and also Supreme Court.
Yes.
Supreme Court, my lord, in SEC 1969 SEC is 873, my lord.
ಏನಂದ್ರೆ citation ಏನು?
1969
ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇದು ಕೊಟ್ಟಿಲ್ಲ ಇದರಲ್ಲಿ ಮೆನ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ, ಈ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಈ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ.
Whatever you have to, you want to rely upon ಕಾಪಿ ಕೊಡಬೇಕು ನೀವು.
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ ಬಿಕಾಸ್ ಐ ಹ್ಯಾಡ್ ಸಮ್ ಲೆಗ್ ಇಂಜುರಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ, ಅದು ಮತ್ತೆ
ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾರೆ. ಇಲ್ಲ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಒಂದೇ ಇರೋದು ಇದು WP 45891.
This judgment is mentioned in the other judgment, my lord. I read, my lord. Just now I read.
1969 SC 1335 Town Municipal College, Athani.
Yes, my lord. This is also said by the Honorable Supreme Court, my lord. The same view has been expressed by the Honorable Supreme Court, my lord.
ಇದೆಯಾ ಮಾಡು? Mr. Omkar, which para you want to refer to?
Para 7, my lord.
Para 7.
The long title, page number. The long title.
Yes, we have examined the application.
Yes, my lord.
Alindana?
The long title. The long title and preamble to the Minimum Wages Act.
ಇಲ್ಲ ಪ್ಯಾರ ಅಥಣಿ ಮುನ್ಸಿಪಾಲಿಟಿ ವಾಸ್ ಲೇಬರ್ ಕೋರ್ಟ್ ಅಲ್ವಾ ನೀವು ರೆಫರ್ ಮಾಡ್ತಾ ಇರೋದು? Which is the citation that you want to refer to? Year 1969 Supreme Court 1335. Para 7 reads differently from what you are reading. Para 6, the long title.
Long title and preamble to the Minimum Wages Act. So that this act was passed with the object of making provision for fixing the minimum wages in the certain employment. The word wages has been given a wide meaning in its definition and quite clearly includes payment in respect of the overtime and for work done on weekly off days, which was required to be given by any employer to the workman and the provision of that act itself. Section 13(1), which deals with the weekly off days, and section 14(1) deals with overtime, are as follows. So these are the. My lord, I'll jump to next para, my lord. In order to provide remedy.
In order to?
Provide a remedy against breach of orders made under other continue.
Yes.
In order to provide a remedy against breach of orders made under section 13(1) and 14(1), that act provides a forum and the manner of seeking the remedy of 20, which is as follows. 21. Appropriate government may by notification in the official gazette appoint any commissioner for workman compensation or any officer of the central government exercising functions as or any officer of the state government not below the rank of labor commissioner or any other officer that with experience as a judge of the civil court or as the stipendary magistrate to be authority to hear and decide for any all crimes arising out of the payment. Payment of less than the minimum rates of wages are in respect of the payment of remuneration for days of rest or for work done on such days under clause B or clause C of the subsection 1 of the section 13 are of wages at the overtime rate under section 14 to employees employed or paid in that area. Where an employee has any claim to the nature referred to in subsection 2, the employee himself or any other legal practitioner or any official of the registered trade union authorized in writing to act in such on his behalf.
What is your submission, Mr. Munkar?
Well, submission is that, my lord, minimum this section 20, my lord, under which the claim petition has been filed, can be filed only for fixation of the minimum wages, my lord.
Not for enforcement and recovery.
Recovery, my lord. In this case, my lord, the government has already fixed the rate, my lord. So this section and act doesn't apply, have an application in this present case.
This judgment is also on the same principle as what you relied upon of our High Court.
Yes, my lord. Yes, my lord.
So the duplication of the citation, there's no new point in this.
Same point, my lord. Same
point.
The reiteration of the same point given by this honorable court, my lord. And limitation part also comes in this, my because after resigning from the job, my lord, even after 1 year, my lord, after lapse of 1 year, he has filed this petition, my lord.
That is what is troubling us, that you are not paid the minimum wages.
But he was not an employee, my lord. He's only a part-time employee. He had to work for 1 hour every day, my lord. Waterman ನೀರು ಮತ್ತೆ ಆನ್ ಮಾಡೋದು ಆಫ್ ಮಾಡೋದು ಅಷ್ಟೇ ಕೆಲಸ ಇರುತ್ತೆ, ಬೇರೆ ಕೆಲಸ ಇರಲ್ಲ. But it was normally the practice, whatever the payment wages paid to the first respondent was the paid.
ಸಾಯಂಕಾಲ ಕಾದ್ಬಿಟ್ಟು ಒಂದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದು ಅಂದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. You are employed him as a waterman. If he works only for 10 minutes or 5 hours, how does it matter?
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಆಸ್ಪೆಕ್ಟ್ ವಿಲ್ ಕಮ್ ಟು, ಬಿಕಾಸ್ ಇದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ವಿಲ್ ಹ್ಯಾವ್ ಎ ಲಿಮಿಟೆಡ್ ರಿಸೋರ್ಸ್ ಮೇಲೆ ಅದರಲ್ಲಿ 40% ಆಫ್ ದ ಏನ್ ಅವರು ಟ್ಯಾಕ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾರಲ್ಲ,
they don't employ people.
Okay, and this condition only
our person that you are employed for something else to discharge this duty also. They are ಬೇರೆ ಅವ್ರಿಗೆ ಹೋಗಿ ಹೇಳಿ ವಾಟರ್ ಪೈಪ್ ವಾಟರ್ ಬಿಡಿ ಅಂತ. You cannot say that he only works for 1 hour. I mean, if he joins somewhere else, then you will say dereliction of duty is joined some other employment.
ಅಲ್ಲ ಪ್ರಾಕ್ಟಿಕಲ್ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ಅವ್ರಿಗೆ ಗ್ರಾಮ ಪಂಚಾಯತಿಲಿ ಏನ್ ರಿಸೋರ್ಸ್ ಕಲೆಕ್ಟ್ ಆಗುತ್ತಲ್ಲ, ಟ್ಯಾಕ್ಸ್ ಕಲೆಕ್ಟ್ ಆಗುತ್ತಲ್ಲ, ಅದರಲ್ಲಿ
you are required to pay minimum wage. That is what is troubling us. You have obviously not
ಸರ್ಟನ್ ಅಮೌಂಟ್ ಅನ್ನ ಮಾತ್ರ ಅವ್ರು ಪೇಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಪ್ರೊವಿಷನ್ ಇರುತ್ತೆ. ಸೊ
then don't employ people, Mr. Omkar.
Milord, normally this is the amount which was given by all the gram panchayats, milord. Now ಏನ್ ಕೊಟ್ಟಿದ್ವಲ್ಲ ಅದನ್ನೇ ಎಲ್ಲರಿಗೂ ಕೂಡ ಕೊಡ್ತಾರೆ. Where all ದೊಡ್ಡ ಗ್ರಾಮ ಪಂಚಾಯತ್,
if you are not able to pay minimum wages, don't employ people. You cannot say as a panchayat, you cannot say I am not going to agree to the law and abide by the law. The judgment is in your favor, but your actions are contrary to law.
Allah, if had he that person working under the same this thing, Gram Panchayat, while filing the application, yes, my lord, I would have abide by the.
ನೀವು ಕೊಡೋದು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯಾರು ಕೆಲಸ ಮಾಡ್ತಾರೆ ನಿಮ್ಮ ಹತ್ರ ಎಲ್ಲ ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ. You don't even pay the minimum wages. Why should they work with you?
Even now, actually, there is no proof that he sought for a minimum wages when he was working, my lord. He was not even put a single application.
Not for him to seek, it is for you to pay. The obligation is.
ಅಲ್ಲ ಏನಾಗಿದೆ ಅವ್ನ್ ಕೆಲಸ ಬಿಟ್ಟಾದ್ಮೇಲೆ ಒಂದ್ ವರ್ಷ ಆದ್ಮೇಲೆ ಸೆಕೆಂಡರಿ ಬೇರೆ ಯಾರೋ ಹೇಳ್ಕೊಟ್ಟಿದ್ದಾರೆ ಇಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನಿಮಗೆ ಅಂತ ಅದಕ್ಕೆ ಹಾಕಿದಾರ.
ನೀವು ಮೋಸ ಮಾಡಿದ್ರೆ ಏನ್ ಮೋಸ ಮಾಡಿದ್ರಿ ಅಂತ ಗೊತ್ತಾಯ್ತು ಅವ್ರಿಗೆ, ಆಮೇಲೆ ಬಂದ್ರು.
ಅಲ್ಲ, ಇಟ್ ಈಸ್ ನಾಟ್ ಓನ್ಲಿ ದಿಸ್ ಪರ್ಸನ್. ಗ್ರಾಮ ಪಂಚಾಯತ್ 78 ವರ್ಕ್ ಬಂದಿದ್ದಾರೆ, ಅಷ್ಟು ಜನಕ್ಕೂ ಕೂಡ ಇಷ್ಟೇ ಪೇಮೆಂಟ್ ಮಾಡಿರೋದು, ಇವ್ರೊಬ್ಬರಿಗೆ ಕಡಿಮೆ ಮಾಡಿದಂತಲ್ಲ. ಯು ವುಡ್ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ when was working in the.
It's your obligation, Mr. Omkar, to pay minimum wages. ನೀವೇನು ಒಳ್ಳೆ ಫೇವರ್ ಮಾಡಿದಂಗೆ ಮಾತಾಡ್ತಾ ಇದ್ದೀರಲ್ಲ, ಮಿನಿಮಮ್ ವೇಜಸ್ ಕೊಡಿ.
ಅಲ್ಲ ಫೇವರ್ ಅಂತ ಅಲ್ಲ ಮೇಡಮ್.
ಅವರು
At least you would have approached the appropriate forum, my lord. That was my contention, my lord, with this honorable court. You are not denying, if at all we have to pay
properly, so they have gone their way to do. ಅವರು ಇಲ್ಲೂ ಅಪೇರ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲೂ ಅಪೇರ್ ಆಗಿಲ್ಲ.
Labor, Mr. Shekhar, respondent has been served but not appeared. Minimum wages so fix ಆಗಿದೆ. Section 20 ಅಲ್ಲಿ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಕೇಳಿದ್ದಾರೆ, ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ. Mr. Omkar is saying that enforceability power ಅಲ್ಲಿಲ್ಲ, payment of wages act ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಾಗಿತ್ತು ಅಂತ, relying on a decision. ಯಾರಿದ್ದಾರೆ? Admittedly, minimum wages have not been paid. Naik or pass over. Mr. Bandari?
Yes, Your Lordship.
Ready?
Next week ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ ಸರ್.
ಯಾಕೆ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಇವತ್ತು ಯಾಕೆ ಬೇಡ?
ನನಗೆ
ಇವತ್ತು ಯಾಕೆ ಬೇಡ?
I was not keeping well. Today morning I came in the office. That is why, Your Lordship.
The respondent submit that he is not well and he seeks for a week's adjournment. ರಿಟೈರ್ಡ್
ಆಗಿದ್ದಾನೆ ಅದಕ್ಕೆ
ಏನ್ ಮಾಡೋದು? Based on 25th.
Yes. Request ತರಿಸ್ಬೇಕಾದ್ರೆ
Why? You are appearing for Mr. Gagan Ganapati. Shri MD Gagan Ganapati has entered appearance for respondent. We wish you directly read the name of Shri BJ Krishna as that appearance for respondent. On behalf of Mr. Ganapati, it is submitted that he is unwell and 2 weeks adjournment is sought for. Released on 1/9. Suffering from COVID and cannot make this submit. Phone ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರ ಹತ್ರ ಮಾತಾಡಿ. ಫೋನ್ ನಂಬರ್ ಇದೆಯಾ? ನೀವೇನು ಯೋಚನೆ 28, Mr. Savkar.
I appear for the respondents counsel, my lord.
Milords, I appear for the petitioner, Milord. Milords, we are ready, Milord. May kindly pass it over, short pass over, Milord. I seek for a short pass over in this matter.
Pass over. Subara pass over.
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ, ಏನೋ ತೊಂದರೆ ಇದ್ರೆ ಹೇಳ್ತೀನಿ ಆದ್ಮೇಲೆ.
ಆಯ್ತು. Pass over ಸದ್ಯಕ್ಕೆ.
Oblige, Milord.
ಸಂಜೀವ್ ಅವ್ರು ಬಂದಿಲ್ವ ಇವತ್ತು? ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಓಕೆ, ಪಾಸ್ ಓವರ್. Pass over. 32 pass over. Yes.
For an employee of Tata Communications for the period between 3/4/1979 to 24/11/1991. Accordingly, he has paid his provident fund dues to the respondent authority during that period. After that, he left that employment and joined another company. Until the year 2017, he has not paid his provident fund dues. Then in the year 2017, he submitted his claim to the provident fund authority. They accordingly considered his claim. They didn't initially pay anything, they just took his application and they kept quiet. After which I issued a legal notice. Subsequent to which they paid a partial amount of 1,14,000 on 18/2021. Thereafter, I had to file the petition because they have not paid me interest on the provident fund dues which had
That
accumulated.
is 1 lakh is the full payment of provident fund.
It was not full payment. So after I filed the writ petition and notice of dispute, they made another payment of 188,000.
Okay.
After the writ petition was filed. Now, given that, my lord, only in the year 2011, you have paid me interest. After 2011, no interest has been paid. Even though the amount was there.
What is the date of payment?
The date of payment is 27/9/2021.
27/9/21.
21.
And they paid interest till 2011.
2011.
So your claim is for interest of 12% from 2/3/17 to 8/2/21.
That is my alternative. The primary reason is to pay interest on fee for the 1979 period. They accordingly they are paid in 2011 that are not included. The balance from 2011 to period is my primary reason. That is my alternative reason. The case is rejected. 12% from 2011.
Alternate and assuming paragraph 66 to be constitutional. You are not challenge the constitutional validity of 66.
I challenge my lord. Challenge constitutional validity.
Now you have given up that.
Yes.
So your Gadilla and the prayer E also has to go. Sorry, prayer C has to go.
Even if it is constitutional, even then I am interested.
About 66. Have you extracted para 66? EPF action.
Not yet.
Interest shall not be credited to the account of member from the date on which it has become an inoperative account under the provisions of para 6 of 72. That is what 66 says. Para 72 again. Two, 6. So you have to make a claim within 36 months. Since you have not made a claim in 36 months, it becomes inoperative in terms of subpara 6 of para 72, bringing into effect subpara 6 of para 66.
And there is an amendment in the year 2016 to para 76 across the country.
1/4/2011. When did you superannuate? When did you superannuate? When did you retire?
I retired in the year 2008.
2008. Let him finish then. And what is the amendment to subpara 6 of 72?
Second, in the year 2011, they introduced the provision saying interest will not be paid if the amount is transferred to the inoperative account. Only from the year 2011, that amendment was brought into force.
But no claim has been preferred with effect from 1/4/2011. Or transferred with effect from 11/11/2016.
So all cases where no claim was preferred, from 2011, no interest is being paid after that amendment.
But only 3 years ಬದಲು 36 months ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. 3 years ಅಂದ್ರೆ 36 months ಅಂದ್ರೆ it's only a innocuous amendment. Unclaimed deposit amount they made it inoperative account. So what is the
both and all the players were inserted by year of 2011. This was not existing before 2011.
What difference does it make on the Mr. Rao? But no claim has been 1/4/2011, but no claim has been preferred. Is the footnote 4.
Interest will not be credited to the account of a member from the date on which it has become inoperative. This was introduced in the year 2011. This is admitted in the statement of objection. Inserted by the CSR dated 15/2011. The subclass 6 itself was introduced in the year 2011.
Subclass 6 was not introduced in 2011. Subclass 6 was introduced in the year 1964. Otherly bits and portion 2011 or 2016 is there. ನಮ್ಮ ಬುಕ್ ಪ್ರಕಾರ ಇಲ್ಲಿ 1964 24 September 1964 subclass 6. ಏನ್ ಮೇಡಮ್ ಯಾವಾಗ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆ subclass 6 of 72? 66 60 okay. Was introduced in 2011, yes.
So my account
No, but subclause 6 of 72 was always in force.
72 was always in force. The question of interest being not paid is by virtue of section para 60 subclause. Only para 60 subclause says interest is not paid if your amount is transferred to the inoperative account. If this is not done, then interest is paid.
Yes, madam.
This person was employed on 1st May 2029 and he has left employment from 26th November 1991.
25th 11
91. Thereafter, when he has taken employment somewhere else, he had to inform us. He has not done anything. Till 2017, he initiated the claim there is no communication from him. And actually, he has attained the age of 58 years in 2007. Thereafter, also, he doesn't make a claim for this project. From 91 till 2017, there is no claim. He makes a claim only in 2017. Now, when he makes a claim, this provision which is there, it has already come into effect. So in 2011, they have made that, so whatever amount is payable to him in 2011, interest, all that they have already.
Is it your contention that within 3 years, 36 months of claim made matra kodtira ನೀವು?
But that is come after 2011. That section has come again to 2011. But this person has not claimed, it became payable to him in 91. Once he left the employment, because he has not informed us that he has joined another base of. So automatically when this section came into effect in 2011, thereafter it was made and till 2011 the interest has been paid. And that is as per the provisions of the Act. Now, initially he had challenged the constitutional validity of this paragraph. Now he has withdrawn that constitutional validity.
Yes.
So now, as per that provision, the interest has already been paid.
Till 2011.
Yes, till 2011. So there is nothing in
Even if it is prospective from that date.
because he was required for now almost 27 years he has not made anything because 91 till 2017. He doesn't make the claim for his provident fund itself. And thereafter also when he has made the claim, he has not furnished us the details and all that we have found out. There are various amendments thereafter. There was a UNA number to be generated by the employer. Now that establishment itself has stopped business operation in 97. Where he was working.
But that number has not even been generated.
Thereafter, we have found out the details from his legal notice, they have got it generated and then this payment has been made to him.
You've been paid interest till 2011. Mr. Gaur.
This provision has been considered by the Punjab and Haryana.
ಮುಂಚೆನೇ ಹೇಳೋದು ಬೇಡ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಕೊಡ್ತಾ ಇರೋದು.
Because of the policy under subparagraph 6 of paragraph 72 and subparagraph 6 of paragraph 60, these clauses cannot be read narrowly in the manner that the interest on the amount will not be paid to the account of the member from the date it becomes inoperative account. Under the provisions of subparagraph 6 of paragraph 72 of 15. The prohibition is merely addressed to the EPF organization for maintaining of its books of accounts that interest will not be credited to the account of the member. But that does not mean that interest should not active when not credited to the inoperative account and stands only deactivated for the time being and can never be brought to life. This is only just an equitable interpretation that can be placed on a social welfare beneficial legislation as the Act. And the scheme of bridge sincerely for the purposes that are meant to serve, in as much as members should not lose their right to their money earning interest acting silently on such amount as keeping the fund while earning interest for the organization. It appears right that an inoperative account should mean an account with a right with respect to interest for last of 36 months from the date it became payable. Inoperative account is only a deactivated account which has been frozen by notification for the time being as an accounting measure in transaction of PF business. But it does not mean that right to interest and extinguish since the principal amount is not money lying in the fund in hard cash, locked in funds, but in the economic flow of money in circulation. The RPSC does not say that the amount lying in the fund are not invested to earn interest under the scheme or not collateral for debt, assets or liabilities or to money show. Thereafter, page 10. Paragraph 9.
Yes.
There is no gain saying that money belonging to the member remains in trust and custody of nuclear organization. The object and purpose of the act is to secure the workers' money lying in this new fund in the shape of investment for wages. In this duty, RPFC or Board of Trustees cannot fail to remain vanguard of the right of marginalized labor who are the weaker section of society for whom Parliament enacted the law in the Nuclear Act 1950. Denial of interest on principal amount for the period in issue is not found just, fair and equitable, and the provisions of the scheme under consideration are meant to be addressed to the organization, advising it how to act in the two situations contemplated by Sakara 6 of paragraph 72, but not to subscriber member to have to take away valuable rights to interest in the provision is not subscriber centric or that very principal act. It comes as some surprise, is not shock that the blood, sweat, and tears of migrant laborers across India lie locked in a coping of rupees 27,500 crores of provident fund and lying with the nuclear inoperative account as of March 2014.
Yes.
Thereafter, the requisition was allowed and similar set of facts. In fact, as of 2017, there's 40,000 crores in inoperative accounts. And the writ appeal was also given.
What is the next judgment? What is the next judgment?
That is writ appeal against the same remit interest order. That writ appeal also opposed the order of the
Yes.
Then the Madras High Court also has considered here. One more fact I have to bring your attention to. In 2016, again an amendment was brought into paragraph 72 subclause 6.
Yes.
There, in 2011, this provision was extended to all inoperative accounts. But in 2016, it was related only to persons who have retired and who have not made the claim or have left the country.
Why have we withdrawn the challenge to the validity?
Because the central government was not filing their objections and all that, and this person is on the verge of dying.
You have withdrawn that challenge. That's not
Because out of frustration, I would withdraw that release, my lord. Because these are senior citizens.
Judgments itಕೊಂಡು ನೀವು withdraw ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? The judgments are all in your support. And you withdrawn the claim.
That this one Delhi High Court judgment which is against me, that also I have to read. This Madras High Court judgment considers the 2015 amendment, my lord, page 17.
Yes.
Admittedly, the petitioner ceased to be in employment from July 2006. Thereafter, after the above amendment provisions of paragraph 6 of paragraph 72, the account became an inoperative account as the admittedly has not made any application for withdrawal within a period of 36 months from the date. That amount became payable. When considering the statutory provision, I don't think that the petitioner is entitled to interest for the period to which such payment of interest was specifically barred in view of the amendment to paragraph 6 of paragraph 72, which affects from 1/4/2011 as stated above. There is no dispute to the fact that the petitioner is entitled to get interest with effect from 11/11/2016 as admitted in the counter appeal in view of the subsequent amendment taken place to paragraph 72 subclause 6 with effect from 11/11.
This is what the respondent has done without the challenge being there, Mr. Your claim for that interest from 2011 will not succeed.
Because here in Madras High Court judgment, the 2016 amendment is being made applicable. In my case, they have not implemented the 2016 amendment. At least let them do that number. At least 2016, again, there is an amendment which provides for the payment of interest on the inoperative account. That is what the Madras High Court has considered here. In the second paragraph, paragraph 9, There is no dispute with the fact that petitioner is entitled to get interest from 11 and 2016.
If there was a claim made within that 36 months, it was model way.
Here also it was made after 36 months.
But now you have withdrawn that challenge to it.
Correct, but I'm not, there also no constitutional validity was not challenged either because the Punjab High Court or because the Madras High Court. Even if those provisions are enforced measures, the 2016 amendment benefit I should get from it. May just take a lot to the Delhi High Court judgment which is against the matter, but it has considered the Madras High Court judgment also. Page number 13.
Yes.
Page number 13.
30. Yes.
Thus, the Madras High Court gave a distinction between interest prior to 2011 and post 2016 amendment of the EPF in 1962. Moreover, the employee consent had not retired from service after attaining the age of 58 years, but had merely ceased to be employed, as is clear from a reading of paragraph 4, which reads as under. When a counsel appearing for the petitioner submitted, as the petitioner has not retired after attaining the age of 55 years, and as there was no occasion for the petitioner to make withdrawal, the respondents are not eligible to limit the interest of the petitioner for this period between 2011 to 2016. Thus, this appears to have been a case of cessation of employment prior to attaining the age of 55 years, wherein a specific change was made in paragraph 72 across of the scheme by notification dated 11/11/2016. Hence, the court has granted interest for the petitioner post 2016. Even in my case, it is not that I retired and then it has become inoperative. In 1991, my account has become inoperative because I stopped working with my employer. So therefore, the benefit of 2016 amendment should be granted to me.
When did you retire?
I retired in 2008, but these given are for the period between 1970 to
The
1991.
same judgment is applied, your cessation of employment prior to 55 years, Baralla, but you retired in 2008, prior to the amendment.
This amendment, it says that if your account becomes inoperative, other than the reason of retirement, then you are entitled to interest on the inoperative account also.
Your account became inoperative in 91 because there was no contribution made after that.
So on that,
So cessation of employment will come into force from 91.
yes, because I left employment in 91, I have within 3 years, I have to make it not, it has become inoperative. In that case, I am entitled for interest. If I have retired and not made a claim, then I am not entitled. Only to kindly see the amendment. If that amendment is still, they have produced the amendment. The Delhi High Court considers the 2016 amendment with their objection towards the response of the page 24 page. Second, the employer provided from 1952 in paragraph 72 of paragraph 2. For the word ceased to be employed, the words retired from service after attaining age of 55 years or migrated abroad permanently to the subsidy.
Yes.
The earlier word was ceased to be employed. So if a person left employment and did not make his claim, then we would go to inoperative account and we would not be entitled for any. Then 2016, they told that we'll bring down this narrow scope and only when persons are attained 55 years or migrated abroad, only then my interest won't be granted and when they are pleased to be employed, interest will be granted. This is the interpretation which Madras People has before based on the policy.
You cannot take into account 2016 when you seized in 2011 or in 1991, and thereafter in the year 2007 you attained superannuation. If in 2016, so for benefit you should have been still working at that time.
Then by that, then even the 2011 amendment cannot be because only by virtue of 2011 amendment, interest is not being given to me.
The 36-month period kicks in. That's why did you withdraw that the challenge and state or Aditya, we could have gone through it. We cannot go into that at all now.
Even in the absence of challenge, my submission, 2011 amendment is being applied to 2016 amendment also has to be applied because it is after these two amendments are made with claim.
2011 is a restriction. 2016 is a claim that you can make if you are in existence at that time. They operate in two different fields.
But my claim is after both the amendments. After 2006, my claim is in the year 2007.
You can make a claim in 2040 also.
They have admitted my claim.
The limitation period which has been prescribed.
But they are not disputed that they have made my payment method after admitting my claim.
For the principal amount, not for the interest. Till 2011, kottidara. As per the amendment, till that cutoff date, they are paid.
Same fact situation, 2008 he had got. If your order is in Madras High Court judgment. Page 15, second paragraph. He was working in a company named Karnataka Limited from 1992 to 2006. He's having case of another for his working period from May 1992 to September 2006. This year also the claim is in respect of the period before the amendment. And the Madras High Court has given him the benefit of the amendment. Last paragraph is not restricted to the fact that traditionally entitled to get interest with effect from 11 that is the date of the amendment. From 2016 to the new payment. Business payment interest is my only submission.
From 11 to 16 you don't want, from 16 you want, Anta is your content. That is your submission. Because you made your claim post 16. Yes, madam. That is what is submission. Finally, distilled version of what Mr. Hemant Rao's submission. And you know it, you give it time, if that is what you want. His submission now is that since he has made the request for payment post 2016, and in the year 2016, a beneficial amendment came to be made, he should be entitled to the benefit of that amendment in the year 2016. 2011 to 2016, being the disputed period, he is willing to give up his claim for interest. Till 11, you have admitted that you have to pay. You admitted and you have paid. 11 to 16 is now his admission saying he doesn't want. But 16, when the amendment came in, the replacement was the word ceased to be employed by retired from service. So your reliance of 1991 being seized would not apply. It has to be retired from service after attaining the age of 55 years or migrated abroad permanently. Therefore, the benefit of 16 amendment has to come to him. So in the year 2016, you cannot rely upon cease to be employed. That is what the Madras High Court has considered. He is not able to explain that firstly. Madras High Court has considered and it said that since the claim was made post 2016, the amended provision would have to be given effective because it's a beneficial legislation. Therefore, from 2011 to 16, no interest. 16 onwards, till the payment, you pay interest on the Madras High Court. Third, Shri Rupodi Rao, Learned Counsel, Shri Hemant Rao, Learned Counsel for the petitioner. Shrimati Nandita Aldipur seeks for and is granted a week's time to make a submission as regards the decision of the Honorable Madras High Court in WP number 29166 of 2017 as regards the interest payable post the amendment to subpara 6 of paragraph 72 in the year 2016. Released on what, madam? 23rd? 23rd.
One office objection. Page number 7. Sanjeev.
So BL Sanjeev has entered appearance for response, which is directed beneath the name of Ms. Renuka HR has got appearance to respond 1 to 3. None appears for the petitioner, released on 25 each. Yes, Mr. Osman? Pass. Tomorrow agala in 19 go. Bandidiralla. 36, the counsel for the petitioner is ready to address his argument. The counsel for the respondent seeks for a passover. And counsel for the petitioner submits that he has some personal inconvenience in the afternoon session. Hence, released on 19. Mr. Pradeep. Are you ready? Okay. So this is the 38 released on next week. They're going to take charge. Released on 6/9. Interim order earlier granted will extend till next week. None appears for the petitioner. Learned counsel for respondent 1 and 2 seeks for and is granted a week's accommodation to file a statement of objection. Released on 19.
Made in September 2021. Till date, no payment is made. In fact, what appears to be the case, my lord, is that the department appears to be confused as to how to make out the higher payment of pension because they have deducted my contribution at a higher rate. The actual reduction normally the maximum pension was kept at a cap of 1,500. By virtue of an amendment to the scheme, international worker was taken out of that and the actual salary was considered as basic salary from contribution. So what happened, like 12%, etc., which was deducted was deposited. When I made the claim for provident fund, the government passed an order reallocating the funds. By redistributing almost 70 lakhs of my funds from the provident fund to my pension. Consequently, I made a claim for pension, which according to me comes to 2,25,000 per month based on principal salary. According to their own admission as per addiction, it comes to minimum of 80,000 per month. Now, based on that, they have raised an issue saying that if we pay this, it will not be sufficient and therefore give us guidelines. When the rules and regulations, everything is in place, and they themselves have calculated.
The guidelines from whom?
They have sought an addiction. A, they have returned to the EPF connection A at page 18. EPF has returned the additional system commissioner Zonal Affairs. May I read this one letter, my lord, that encapsulates the entire dispute. With respect to the above, this office does not clarification from head office regarding the process of pension in respect of international workers on the basis of form 10 and international workers. While crossing this pension remains under difficulties are noted in this clarification of sought from head office in this matter. In continuation of the earlier cited letters from the point, the kind of issues in matter certain technical and legal issues that are noticed when crossing the pension claim in respect of international workers. Being an international worker, pension contribution towards pension trust was paid by member on wages over and above the city of 1,500.
15,000.
15,000. The system restricts the UPS wages to wage people and crossing the wage. As per
Just a minute. Being was paid by the member on wages over and above the wage ceiling of 15,000, but the system restricts EPS wages to wage ceiling. What is the wage ceiling?
That is the wage ceiling as per the scheme.
It's a systemic 15,000 is the wage ceiling.
Yes, sir. As per para 11 of the scheme, 15,000 is deemed to be the maximum pensionable salary.
So there was paid by member on wages over and above the wage ceiling of 15,000, but the system restricted to 15,000. It's a systemic issue, software issue.
Software issue, and the fact that they realized that they have to pay higher than what they had planned for.
That time, that they won't be bothered about. How much ever you have to get, you will get. But what is the process that they have to follow is this.
That is 50,000, the first point. As per para 11 of para 43 of the EPS scheme, pensionable salary should be the average monthly pay drawn during the entire contributed period of service to the membership of the employee's pension fund. Since no separate model is there for crossing the pension line in respect of international worker, worksheet will be capturing the wages of only last 16 months. It may also be clarified as whether TDS would be required to be deducted from the pension of international worker under Section 190 of the IDA, and annual pension in respect of international worker would be more than the limit of 2.5 lakhs, 3 lakhs. If yes, then no provision exists in the system for such TDS deduction on a monthly basis. Though not applicable in the instant case, as the office has started receiving many such form tables for crossing claims in respect of international worker, the following issues may also be clarified. One, procedure for crediting monthly pension in an overseas account in respect of members belonging to SSA country. The eligibility and modalities for member of non-SSA country for claiming pension and its monthly disbursement in an overseas account. Legal issue. As per manual calculation of pension in accordance with para 43 and para 12 of EPS 1995, the approximate monthly member pension in respect of state member would be around 80,000, 9.6 per annum. The total contribution made in respect of the member towards the pension fund towards contributing 44 lakhs in 2004, around 70 lakhs approximately and compounded monthly 8.5%. It effectively means that pension in respect of international worker would be paid out of the own contribution only for a period of 7 to 10 years, which is up to 6 years. And for the remaining years, it would have to be paid utilizing funds contributed by domestic Indian workers towards pension fund by limiting it to wage ceiling, resulting in cross-subsidization. Since the ongoing higher pension claims before the honorable EPS has offered grant of higher pension to ineligible members, citing a cross-subsidization of funds would result in reversal of funds. It may kindly be examined as whether crossing pension of higher pension to a foreign actor while remaining the same and Indian domestic workers would give partners of person in higher pension case in order to Supreme Court. Since this is the first case, probably on an all India basis, where pension is processed to an international worker, and as the monthly pension amount is on the higher side, the once again request to take up this issue with the head office seeking clarification on the points raised above, and also to issue standard operating procedure for processing pension claims in the of international workers. Make necessary modifications in application software, preferably a separate model for processing the same by incorporating necessary checks to preempt any overpayment in this regard. The modalities of pension payment overseas bank account and the type of bank account to which pension can be paid in respect of foreign nationals by bank account in India. Examine the legal and technical issues cited above and provide clarification in this regard. Then, my lords, in response to my last request for releasing of the pension, my lords will find that at page 12 of my petition, where I have extracted in a table format all the applications made and all the responses given. At page 12, point number 12, I can inform in the last column, madam, the meeting at the highest level in this regard are held to DPA for head office on 21/4/2022. In the meeting, a committee was formed by office order 22/4/2022 to finalize the modalities of pension calculation and disbursement for international workers and submit its report in a time-bound manner. The matter of this clearance comes under the terms of the reference of officers committee.
So that is still not happening.
And also not. And what is in April 2022, they made form a committee. Even after that, even today, there is no release.
Who are the members of this committee?
This, the only information I have produced at page 22, my lord, of the petition. That only discloses that terms of reference of opposite committee are in one. That is all it discloses.
Then please request the additional central PF commissioner, headquarters, zonal office, Bengaluru, to be present on the next date. If not, if you don't receive instruction by next date, 3 weeks we don't give. We'll give you 2 weeks max, because this has been pending for some time, and this has been pending for more than 1.5 years. Your authority, we are not concerned only with the petitioner. Even as per this letter, we have received so many applications. And in all these, the points which have been raised are important. Yes, we understand that there cannot be a cross subsidization, but there has to be a SOP which has been done and some action to be taken and processed. So this is what is due and not due. This cannot be pending for nearly 1.5 to 2 years. Not only the petitioner, but too many applications are being received is what your officer only says. Fruits of a poisonous tree. How did you get this copy, Mr. Sridhar?
By email, response to my query of what was letter. They have said that we have asked for clarification and that's been sent to me by email disclosing that. And in fact, the reason why I also that's for the urgency, my lord, as per the 17A paragraph of the pension scheme, within 20 days of the claim, it has to be released. 8 days, 12% interest is payable by the commissioner. So, actually, my lord, 12% return only on releasing is a very good return, but why it is lower of sometimes personally.
Nandita Aldipur, where transfer for respond number 2 and 3 seeks for and is granted 2 weeks time finally to file a statement of objections. A perusal of the letter dated 1/12/2021 at Annexure A to the petition indicates that there are serious issues regarding international workers and the pension payable to such international workers being held up on account of there being no standard operating procedure, the software application deployed not being able to cater to international workers, And also there being various issues relating to modalities of pension payment to the overseas bank account of an international worker, more so relating to tax deduction at source under section 192 of the Income Tax Act and several other issues. These issues from a review of the documents indicate have been pending for more than a year. And the petitioner has not been able to receive the pension amounts due to the petitioner, though the same ought to have been cleared within a period of 20 days. In view thereof, the respondent is granted 2 weeks' time finally to file a statement of objection detailing out the steps to be taken, more particularly that mentioned in the letter dated 1st December 2021 at Annexure A. If objections are not filed by 29th August 2022, the additional central, we are posting by 2nd September 2022, the additional central PF Commissioner Headquarters, Zonal Office, Bengaluru, 560013, shall be personally present before this court on 6th September 2022. Previous on 6th September. If it is not. If it is filed, then it doesn't need. Because we are troubling for instructions, we are nudging that instruction. Mr. Naik, before you start this, there's one other matter in serial number 25. Yes. Mr. Omkar was appearing in that matter. Respondent has been served and remained unrepresented. The respondent had filed an application under section 20C for payment of minimum wages. Payment. Minimum wages had already been determined. Notify agide. The panchayat is saying that we had employed him only for 1 hour as a waterman. Therefore, minimum wages is not applicable. And I one the submission that is rejected. But they relied upon a decision of the Apex Court in 1969 Supreme Court, where the Supreme Court says that under section 20C, it can only be for determination, not for enforcement. Enforcement, you'll have to go under payment of wages. Now, being a statute, being the panchayat and a local body, we are not. Everything is okay. That's all a file note for you, 25. Because the worker has been unrepresented. Yes, no. 25 file for you. No, last time ಅಲ್ಲಿ ನಾನು ನೋಡಿ ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೀವಿ 42 42 you are appearing for whom, madam? For this case. Respondent number 2 and 3. Mr. Bandari. No. For R2, na? Ms. Renuka HR has entered appearance for respondent number 2 in registry. Ms. Renuka HR has entered appearance for respondent number 2 in registry is directly read the name of Sri Harish Bandari and Sri S.B. Srikanth as that appearing for respondent number 2. On behalf of Ms. Renuka, a short adjournment is sought for readers on 13/9. Readings to complete agila. You want to file any objections? You want to file any objections? ಇಲ್ಲ. Connected. Objections, if any, in the meanwhile.
Number 43, address 44.
44. So Ram Charan. ಬಂದಿದಾರಾ? Will pass over? We are not ready. Though counsel for the petitioner is present, none appears for the respondent. Released on 1/9. It is made clear that if none were to appear for the respondent on that date, the matter will be taken up for consideration in their absence.
45. Varadkar Javaldar.
Mr. Havaldar? Yes.
Not the argument.
Huh? 18th, ನಾಳೆ 19th ಆಗಲ್ಲ, 18th ಅನ್ಬೋದು. 18th ಆಗಲ್ಲ, 18th ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. 1st September. Inconvenience. Then we'll have it on 6th September. The counsel for the petitioner submits that he has filed a synopsis of dates and events and submission and written submissions. He seeks for a week's time to make his oral submissions. Released on 6th September. You have filed any written submission yet? You want to file anything? You want to file any submissions? The counsel for response submit that she does not intend to file any written submissions or synopsis of dates and events. Pranab now, pass over. Okay.
25.
I not
Okay.
Well,
28. Subarao, Madhyana.
31.
ಇವತ್ತು ಪಾಸ್ ಅವರೆಲ್ಲ ಇದೆ, ಇವತ್ತೇನ್ ಯಾವ್ದು ನಡೀತಾನೆ ಇದೆ, ಇವತ್ತು ಮುಗಿಯತ್ತಾನೆ ಪಾಸ್ ಸ್ಟಾರ್ನಲ್ಲಿ ರೆಡಿ ಸ್ಟಿಲ್ $59 of the petition. Yes.
The whole issue pertaining to the way of public reason we should have As per the word of that there is misconduct. So the finding that there is misconduct is found, that is conclusion of the anyway, looking facts and circumstances of the case and background of the case, evidence on record in university located in the house. That was, I'm of the complete opinion that the removal of the party was in services. The second party for this misconduct, period for the it does not say that I violated this while conducting immediately because of this misconduct, it is not. For which reason there are several conditions. In fact, I was not
Where are these emails? M3 to M7? Seven. What is wrong with this 97, 98?
He does not approve of superior officer. Instead, he will directly write to the management regarding others without any supporting material.
Who is this?
So, we saw that
No, these emails are one email is from the respondent to Mr. Praveen Churan in reply to the email of Praveen Churan to the respondent. What is the designation of the respondent?
When we seek the provided material to the family, he says that I'm not a police officer to get my access. But if goes on to make not producing anything.
Assistant manager security.
All the emails are summarized from page 43. The last 3 lines.
The designation you said is assistant manager security. What are the roles and responsibilities? What are the roles and responsibilities of the respondent? Assistant manager security. Only appointment letter only. What are his roles and responsibilities? 93. What are his roles and responsibilities? Yes. 30th September. We don't have it yet. Yes. I saw a copy on the other two citations. To give a copy to him. There's no acknowledgement on this memo of citation. Copy to the password. Thirty-nine. 39 empty model. External next day. 25 note grams. Mr. Omkar?
My lord. I'm here.
Yeah, you are audible. You are requested Mr. Naik to assist us.
There are four issues. Officially, regarding issue number 2 about relationship, P1 and 2. P1 is the order and the resolution passed to the appointment is there. And the salary of monthly is 400. So two things are extra from this. Then he is appointed. Salary was very important. But the establishment is followed in the Human Act. That is the verdict. Section 27 of the guidelines. Therefore, what is the difference that becomes payable? But then, you know, he approaches the argument. That is not this entire cannot have to provide. One thing that is equal
the enforcement section 20 al baratta anta. The judgment, Supreme Court judgment says enforcement baralla anta. And our judgment nodidra adu. That is what is bothering us. ಇನ್ನೂ ಒಂದು ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ ಅದು ರಿಟ್ ಪಿಟಿಷನ್. Yes, 33C2. Not under section 20 anta. The dispute as regards the quantum of minimum wage.
The quantum is 88,000 is determined. Based on the salary is all that. And what is actually required to be paid on minimum question. That was some 98,000. And it cannot be once minimum wage is not paid. Then what is penalty? What pay market? Our municipality is apply over there.
ಯಾಕೆ ಅಪ್ಲೈ ಆಗಲ್ಲ?
Section 20 of the minimum cannot be invoked in respect of application. In which we try to it is not bonded. Application is not barred by section 21 of the minimum wage act. This is what they have got. Been an invested section 32. Application timing, computation of benefit for whatever and work done on weekly hours, yet at certain rate, yet needed in the application, not distributed by the employer. Jurisdiction of the labor code, the entertain application, not government section 21. Because they you have to go only under the minimum wage tax. They say not even 36. Easily, I think they are only at 1.
The submission of Mr. Omkara is that under section 25, the authority could only determine what is the minimum wages and not levy a penalty and direct payment of the amounts. Hello, Mr. Omkar?
Yes.
Yes, ma'am.
Anyway, that we did not hear. The argument argued.
Some allowance was not included. Why you are not allocated the minimum? You getting included and over and above the minimum is so of course I feel correct that particular allowance is part and parcel of wages.
Either they as the number judgment is also. Okay. There's no dispute on the road. The last paragraph. Last paragraph.
If there is no dispute as to rate between the employer and the employee, section 21 is not acted. The purpose of section 21 is to be ensure that the rate set in the minimum tax are compared with by the employer in making payment and minimum rate to make payment at lower rate. The person was given the right to invoke. Here out the authority appointed in section 21. In cases where there is no dispute as to the rate of wages and the only question is whether a particular payment at the agreed rate in respect of the minimum wages work time or work on off day is to be a workman or not, the appropriate revenue is provided under the payment of wages tax. If the payment is returned beyond the time permitted by the payment of wages, and even on the ground that the amount paid by the workman is not due, or if the amount paid by the workman is not paid, on the ground that the deduction ought to be made by the employee can seek his remedy by an application of section 51 of the payment of the tax. In the case where section 50 of the Payment Act may not provide adequate remedy, the remedy can be under section 33. Here, in this case, if there is no dispute
as regards the minimum wages payable, there won't be a separate determination required to be done. And but it's 24 all order money, 25 all recovery order agade. Yes, Mr. Omkar.
My lord, it's purely not applicable on one more ground, my lord. Because, my lord, according to this Minimum Wages Act, my lord, section 2I, my lord, only employee or any registered trade union or a legal practitioner can file on behalf of the employee, my lord. In this case, my lord, at the time of filing this claim application, my lord, the first respondent was not an employee, my lord. He resigned job 1 year back before filing this application, my lord. And he has no
But he is
authority
making a
or
claim
no.
for the period during which he was your employee. Is not that is not your employee. Not an employee and adu bere. And an employee madilla and we agree. But for a period
One
he
more
was
ground for. Yes, my lord.
there is not
That is
for
one
the
more
panchayat
ground
to take up these kind of submissions.
No, my lord, no. My
Not a
submission is,
private
my lord,
employee.
this is one more. He is an employee, but not at the time of filing this application. Hence, on this ground also,
Right.
this is Minimum Wage Act is not applicable, my lord. That is my
So
submission.
Nimdo contention more when he is not an employee as on the date of the
Yeah, at the time
application.
of. Yes, my lord.
Yernedo,
And
under section 20, your contention is that there cannot be a determination made and recovery proceeding initiated.
Yeah, it's already
The
determined.
submission
Minimum
is
wages.
that at the most it could be a determination made, no recovery. Recovery has to be in the Payment of Wages Act or under section 33 2C of the ID Act.
Yes, my lord. That is my
Is your
submission.
submission. Alva?
Liberty may be. Yes, my lord.
ಆಮೇಲೆ ಅವ್ರನ್ನ ಅಲ್ಲಿ ಕಳಿಸಿ ಅಂತ ಇದ್ದೀರಾ.
That is the only remedy, my lord.
As a
We don't
consequence.
have any objection. Yeah, my lord. We will, with a time bond, matter may be remitted back, my lord, for a fresh
We are not
consideration. We will
agreeable,
go
Mr. Omkar. We are dismissing your petition.
The employee himself or any legal practitioner. So according to any immediate because that matter one of those five was anything therefore not necessarily that narrow technical point employee
We deal with that.
but dismiss the employee also idea.
Petitioner is before this court seeking for the following relief. The petitioner, Kartikere Gram Panchayat, had appointed the first respondent as a waterman on 28/9/1998. The first respondent claiming that the minimum wages have not been paid in terms of the notification issued by Government of Karnataka dated 17/3/2006 had filed a complaint with the second respondent authority to make payment of the balance wage amounts from 1/4/2007 to 31/3/2011 amounting to rupees 98,521. The notice having been issued to the respondent filed his counter statement, and after hearing the parties, the second respondent passed the impugned order, wherein the petitioner had been directed to make payment of balance minimum wages of rupees 98,521 and further amount of rupees 98,521 as compensation within 30 days of passing of the said order. It is agreed by the same that the petitioner is before this court seeking for the aforesaid relief. Shri K.B. Omkar, learned counsel appearing for the petitioner, would submit that the first respondent is not an employee workman of the petitioner, in as much as he was appointed as a waterman from 28/9/1998 and would only discharge work for a period of an hour at the most and every day, since the only job of the first respondent was to open the taps and or close the taps, which would not take more than 1 hour a day. And as such, he is not employed for the entire day and therefore is not an employee. Secondly, he submits that when the claim petition was submitted, what is the date of the claim petition?
14/3/2012, madam.
14/3/2012. The first respondent had ceased to be an employee of the petitioner on 4/4/2011 when the first respondent stopped coming for work. The claim petition having been submitted beyond a period of 1 year after the first respondent stopped coming for work, no application could have been filed by the first respondent since he was not an employee of the petitioner as on the date on which the application was being filed. And in this regard, he relies upon subsection I of section 2 of the Minimum Wages Act 1948, bracket hereinafter referred to as MW Act. Relying on the same, he submits that for a person to make an application with the second respondent authority, such person ought to be an employee as on the date on which the application was filed. The employment of the first respondent having ceased on 4/4/2011, the application having been filed on so and so date. Being after the period of employment, no such application is maintainable. Thirdly, he submits that any claim made under section 20 of the MW Act could only be for purpose of adjudication of the minimum wages liable to be paid. There cannot be recovery proceedings. There cannot be an order for recovery under section 20. Inasmuch as any such recovery would have to be done in terms of the Payment of Wages Act and or by filing a necessary industrial dispute in terms of section 33(2)(c) of the Industrial Disputes Act. And as such, he submits that the second respondent authority having directed payment of the monies within a period of 30 days is beyond the purview of section 20 of the MW Act, and as such the proceeding, the order, impugned order is required to be quashed. Ashtala, Mr. Omkar. In this regard, he relies upon the decision of the Apex Court in AR 1969, Supreme Court 1335. More particularly, para 7. Para 6 and 7 thereof, which are reproduced here and there for easy reference. He also relies upon the decision of this court in WP number 45891 of 2013, dated 17 July 2014, more particularly para 6 and 7 thereof, which are reproduced here and there for easy reference. By placing reliance on the above, he submits that the enforcement of minimum wages is required to be done in terms of section 15(1) of the Payment of Wages Act 1948 or under section 33(c)(2) of the Industrial Disputes Act 1947. Therefore, he submits that the above petition is required to be allowed and the reviewed order be quashed. Since the respondent workman has been served and none has entered appearance for the respondent workman, this court, considering the import of the arguments advanced by Sri K.B. Omkara, requested Sri V.S. Nayak, a counsel who practices regularly on the labor side, to assist this court. Sri V.S. Nayak, learned counsel, submits that in terms of section 20 of the Minimum Wages Act, MW Act, the concerned authority can direct the payment of minimum wages if not already paid, as also impose penalty for such non-payment, which can be up to 10 times the amount not paid. In the present case, admittedly, the minimum wages has not been paid by petitioner to respondent number 1 employee, and as such, the determination of the amount payable and the levy of penalty is in accordance with subsection 3 of section 20 of the MW Act, and as such, the same cannot be found fault with. As regards the submission relating to determination of minimum wages, he submits that the minimum wages have been determined by issuance of a notification. In that regard, there being no dispute as regards the quantum of minimum wages payable and or applicable to the respondent number 1 workman, the authority, the second respondent authority, was only required to verify the amount of payment made and difference, if any, which is what the authority has done. And as such, there is no determination of any dispute relating to the rates of payment of minimum wages. And as such, the decision in WP number 45891 of 2013 would not be applicable to the present facts. Similar is the submission as regards the decision of the Honorable Apex Court in so and so, inasmuch as he submits that even in that decision, there is a dispute as regards the minimum wages liable to be paid, and it is only in such case that an industrial dispute in terms of section 33, capital C bracket 2 of the ID Act was required to be raised. In the present case, there being no dispute as regards the minimum wages to be paid, the decision of the Apex Court would not be applicable. Lastly, he submits that since the dispute as regards non-payment of minimum wages has been raised, as regards the period in which the petitioner, respondent number 1, was employed by the petitioner, the question of the application being filed subsequently, on which date respondent number 1 was not an employee, is irrelevant for the matter. On all the above grounds, we submit that the order passed by the second respondent authority, being proper and correct, is not required to be interfered with by this court. Third, Sri K.B. Omkar, learned counsel appearing for the petitioner, Sri V.S. Nayak, amicus curiae, learned counsel who has been appointed as amicus curiae in the matter, and perused documents. The points that would arise for determination by this court are: 1, whether an employee raising the issue as regards non-payment of minimum wages is required to continue to be employee as on the date on which the dispute as regards non-payment of minimum wage is raised. 2, whether the appropriate authority under section 20 of the MW Act can determine the amount of minimum wages not paid and impose penalty on the employer for non-payment. 3, whether the recovery of any such amount can be made in a proceedings under section 20 of the MW Act, or would proceedings under section 15 of the 15(1) of the Payment of Wages Act 1948, or under section 33, capital C bracket 2 of the Industrial Disputes Act 1947 be resorted to? What order? Point number 1. Say subsection 1 of section 2 of the MW Act 1948 reads as under. A peril of the above provision would indicate that an employee means any person who is employed for hire or reward to do any work, skilled or unskilled, manual or clerical, in a scheduled employment, in respect of which minimum rates of wages have been fixed. In the present case, it is not in dispute that the respondent number 1 was employed by the petitioner until 4/4/2011. Of course, the contention of the Learned Counsel for the Sri Omkar Learned Counsel for the petitioner is that the claim was made subsequently in the, what is the date, Mr. Omkar? Claim date? I'll mail it. So it's made after 1 year on so and so.
14/3/2012.
14/3/2012. The issue as regards the claim to be raised is not as regards whether on the date of the claim the person is an employee or not, but as to whether the person was an employee and not made payment of minimum wages. Thus, in my considered opinion, the fact of respondent number 1 not being an employee on the date on which a claim petition was filed for this purpose would be irrelevant, since the claim is for the period between 1/4/2007 and 31/3/2011, when first respondent had been employed by the petitioner as a waterman. The relevant period being the period of employment. The question of the claimant not being an employee as on the date on which the claim petition is filed is irrelevant. As regards the further contention that first respondent was employed as a waterman and would only discharge work for a period of 1 hour a day, I have the considered opinion that the same is also irrelevant for the matter, since the employment being accepted, the period during which such an employee discharges its function is left to the employer, and for the employer to take out as much work as possible from the employee, merely because the employer is not able to get work done by the employer does not have work for the employee to do, and the employee finishes his work within a period of 1 hour, would not be a ground for the employer to contend that minimum wages are not required to be paid. The last contention in this regard being addressed by Mr. Omkar, Learned Counsel for the petitioner, is that the financial outlay of the petitioner, Gram Panchayat, not contemplating minimum wages, and if minimum wages were to be paid, it would affect the financial outlay of the petitioner, is another contention which can only be noticed for being rejected, inasmuch as the petitioner Gram Panchayat cannot, on the basis of its financial outlay, contend that minimum wages will be paid or not paid. Once a person is employed and the employer has been notified and minimum wages made applicable to the employer, it is for the employer to make payment of the minimum wages, whether the employer has financial wherewithal or not. For all the aforesaid reasons, I have the first opinion. I answer point number 1 by holding that a claimant need not be employee as on the date on which a claim petition has been filed. The employment is for the period during which minimum wages, it is required for the employee to establish that he is an employee as on the date on which the minimum wages was not paid. And the aspect of number of hours work done and or the financial ability of the employer has no role to play insofar as payment of minimum wages is concerned. Point number 2. Section 20 has been reproduced here and above. A perusal of MV Act is reproduced here and above. A perusal of the same would indicate that any person aggrieved by non-payment of minimum wages for work done can make a claim in terms of subsection 1 of section 20 to the appropriate authority appointed under subsection 1 of section 20 for direction to make payment of the minimum wages. In terms of subsection 3 of section 20, after giving the employer an opportunity of being heard, the appropriate authority would require to consider whether the employer has made payment of the minimum wages or not. And if such minimum wages is not paid, direct the payment of such minimum wage with penalty not exceeding 10 times the minimum wages payable. In the present case, not only is the petitioner notified, not only is the petitioner a notified employer, but the minimum wages as regards that payable by the petitioner has also been fixed by an appropriate notification. Thus, there is no dispute as regards the minimum wages which is required to be paid by the petitioner to its employees. The only contention which had been urged as regards non-payment being on account of lesser amount of hours of work and the financial outlay of the petitioner has been rejected in answer to point number 1 above. There being no dispute as regards the quantum of minimum wages paid, I have the considered opinion that the decision relied upon by Mr. Omkar in WP number 45891 of 2013, which has been extracted here and above, would also not be applicable, since that was a decision which contemplated and dealt with dispute as regards rates of payment of overtime and for work done on weekly off days, which has nothing to do with minimum wages and related to a dispute under the Payment of Wages Act. Thus, I have the considered opinion that section 15(1) of the Payment of Wages Act would also not be applicable to the present facts, and the appropriate authority in terms appointed under subsection 1 of section 20 can consider an application, apply the minimum wages, determine the minimum wages payable in terms of the applicable notification, determine the extent of amount not paid, and direct such payment to be made by the concerned employer. In the event of the said amount not being paid within the time prescribed, then in terms of subsection 5 of section 20, the said amount could be recovered as a fine imposed by the authority as a magistrate, if the said authority is a magistrate, and if not a magistrate, by any magistrate to whom the authority makes an application in that behalf, as if it were a fine imposed by such magistrate. In the present case, the second respondent authority, not being a magistrate, it would be open for the second respondent authority to act in terms of subclause B of subsection 5 of section 20 and forward the same to the magistrate for enforcing recovery. In view of the, I answer point number 2 by holding as in the point number 3. In view of my answers to point number 1 and 2, there are no grounds made out in the present writ petition. The present writ petition stands dismissed. This court places on record his appreciation for Sri V.S. Nayak, known as Amicus Curiae, in assisting this court. ಸಂಜೀವ್ ಯಾವ್ದೋ ಇದೆ ನಿಮ್ದು ರೆಡಿನಾ? ನಿಮ್ದು ಶೇಖರ್ ಅವ್ರದ್ದು ಇಲ್ಲಿ ತೆಗಿದಪ್ಪ ಇಲ್ಲ.
Okay. ಈಗ
Court officer. Court officer.
Court officer,
ಹೇಳಿ ಸರ್.
serial number 7 office objection comply ಮಾಡಿದೆ.
ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿದ್ರ ಸರ್?
ಹಾ ಕಟ್ಟಿದೆ.
ಸರಿ ಸರ್, ಬಂದ ತಕ್ಷಣ ನಿಮ್ಮ ಮ್ಯಾಟ್ರೆ ಫಸ್ಟ್
ಹಾ
ಅವಾಗ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ 28 ಪಾಸ್ ಓವರ್ ಇದೆಯಲ್ಲ,
ಇದೆ ಸರ್, ಇದೆ.
ಮಧ್ಯಾಹ್ನ ಕರಿತೀರಲ್ಲ?
ಮಧ್ಯಾಹ್ನ ನೀವು ಥರ್ಡ್ ಮ್ಯಾಟರ್.
ಥರ್ಡ್ ಮ್ಯಾಟ್ರಾ? ಓಕೆ ಓಕೆ.
Court officer? Court officer? ಕೇಳ್ತೀನಿ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳ್ತಿದ್ಯಾ? ಆಡಿಯೋ ಅನ್ಸ್ಟೇಬಲ್ ಇದೆ ಅನ್ಸುತ್ತೆ. ಆಡಿಯೋ ಅನ್ಸ್ಟೇಬಲ್ ಇದೆ.
Manual to use the same.
Both of you agree for it? So what is the offer that you are making? Are you willing for any compensation in lieu of reinstatement? ಯಾವಾಗ ಹೇಳ್ತೀರಾ ನೀವು? You'll have it after 10 days. Yashwant Anand, the senior counsel, submits that the respondent, the petitioner, does not have any confidence in the respondent to reinstate the respondent, and as such, the petitioner is willing to offer a one-time compensation in lieu of the order of reinstatement passed. He submits that given 5 days time, the proposal would be conveyed to the party in person. The party in person who is present before this court seeks for 5 days time thereafter to consider said proposal and make a submissions. Released on 1/9. Yes, Mr. Bandi.
My lords, the Center for E-Governance, which is responsible to implement this order, has written a letter, my lord, their central web portal has designed the dashboard and implemented in all the departments, my lords. And also they have given a manual regarding how to use it also in the very same thing.
Produce ಮಾಡಬೇಡಿ website print
And
out
my lord, the copy of that particular letter by a central e-governance, my lord, I already sent it to the register, my lord. At the same time, I'll file it in a register also, my lord, the copy of that.
Produce the manual also, will make it a copy, part of the order.
Yes,
so
my
that people
lords.
could follow it.
Yes, my lords. And that particular manual, my lord, in every department, my lord, along with that particular dashboard, that manual is also provided there.
Yes, now we'll have to let people know that you have this facility, alva?
Yes, my lords.
For people to use it. ಒಂದು ನೀವು ಮಾಡಬೇಕಾಗಿರೋದು ಇನ್ನೊಂದು ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗಬೇಕದು ನಿಮ್ದು ಈ ಫೆಸಿಲಿಟಿ ಇದೆ ಅಂತ. You produce it, will make it part of the order and direct the information dissemination on that.
Yes, my lords. Yes, my lords.
ಯಾವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ?
My lord, ನಾನು ಅದನ್ನ ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡು ಒಂದ್ ವಾರ ಟೈಮ್ ಕೊಡಿ, ನಾನು ಲೆಟರ್ ಮತ್ತದನ್ನು.
Sri Dayanand Bandi, Learned Counsel, appearing for respondent number 1, submit that the Center for E-Governance has set up a web portal for the purpose of online application on the Right to Information Act and processing thereof. Given a week's time, we submit that you would produce necessary documentation in respect thereto, including the user manual and the steps taken by the respondents to disseminate the information as regarding the web portal. Released on 22nd. Agat Ashtarga?
25th or 26th, man.
Released on 26/8.
Yes, ma'am.
Tail number another 32, interim order earlier granted with extent and next day. Where was Mr. Ramesh?
I am appearing for the petition. Office objection complied with, madam.
Office objection complied. Respondent are Obrena. Nyaristo. Learned counsel for the petitioner submit that he has complied with the office objection registry to verify. Learned AG accepts notice for respond number 2 and 3. Counsel for the petitioner to furnish copy of the petition along with annexures thereof on the counsel for the cavator as also on the learned AGA. Objections, if any, by 5-9, relist on 8-9. ಮಾಡ್ಬೋದಾ? IA 1 of 2022 has been filed seeking for correction of certain typographical errors in the order dated 3/6/2022. The counsel for the petitioner submits that the reference to a suit number in paragraph number 3 at page 4, line 1 has been wrongly shown as OS number 7664 of 2014 when it ought to have been OS number 2458 of 1993. Registry, the said submission is accepted, there being no opposition on part of the counsel for respond number 1. Registry is directed to carry out necessary correction. Amala? To add after para 11 bracket Roman 2 within a period of 4 weeks. To add at the end of the para 11 bracket Roman 2 within a period of 4 weeks from date of receipt of a copy of the charge. IA 1 of 2022 is allowed. Mr. Subrao. Mr. Subbarao, please unmute yourself.
We will do it. You do, sir. It's here. Yes.
ಡಿಸಿಷನ್ ಇದು ಹಾಗಾದ್ರೆ ಅಲ್ಲಿ ಹಾಕೋದು ಅಲ್ಲಿ ಹಾಕಿ.
Yes, Mr. Subrao, serial number 28, Mr. Saukar is here. Really, Mr. Saukar. ಸ್ವಲ್ಪ ಮೈಕ್ ಆನ್ ಮಾಡ್ಕೊಂಡು ಮೈಕಲ್ಲಿ ಮಾತಾಡ್ಬೇಕು, ಅವ್ರು ಕೇಳಿಸ್ಬೇಕು. ಸೌಂಡ್ ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಕೇಳಿಸಿಲ್ಲ ಅಂದ್ರೆ ನಮ್ಗೆ ಮುಂದೆ ಹೋಗಲ್ಲ. ಮಾತಾಡಿ ನೋಡಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮಿಸ್ಟರ್ ಬ್ರೋ? ಮಿಸ್ಟರ್ ಸಾವ್ಕಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್
ಅವ್ರು ಹೇಳಿದ್ದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ,
ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳ್ಬೇಕು.
At page 288.
Yes.
This is the one of past constitutional management which is part of the 6/2/1999. Hereby, second party is direct to the first party into the original court with the very important by the certificate service law. On the basis of a certificate issued by the Telecast stating that he does not belong to own the caste which is scheduled tribe, which is not scheduled tribe. In fact, you also may kindly see Annexure B, page 25.
Yes.
But this certificate was issued by Tahsildar Bangalore, saying that he belongs to both communities. Now, because he was not born in Bangalore and certificate that was issued by Tahsildar on the place where he was born, he was asked to produce the certificate from either district, Halki, where he was born. Now, kindly see Annexure C, page 26.
Yes.
This was issued. Now, Lord, this was sent for verification. In fact, Lord, you also kindly see, kindly bear in mind that at this point of time, every party's judgment was not there. The verification and issuance and validity was as per the 1990 Act. In fact, Lord, the amendment came in pursuant to Madhuri Party, constitution of the District Caste Verification Committee, and then amendment to that act by insertion of section 48 of 4D came in 8/2/2000. We get to the provision.
The certificate was issued on 93.
Yes, 93. However, after it was sent for verification, now we will kindly see Tahsildar issued a fresh certificate dated 24/3/95, which is at page 13. And you see page 13. Tahsildar Bhatt, I take a worship through this.
Yes.
This is Shri Narendra Amir Humantappa, Proceedings. Shakti Kumar Pranjita, ವೇತನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಆಲ್ಪೀಯರವರ ಮುಖಾಂತರ ಮಾಲೀಕ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಲಾಗಿತ್ತು. ಸದರಿ ಸ್ಥಳ ತನಿಖೆಯ ಸಮಯದಲ್ಲಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೀದರ್ ಪತ್ರ ನಂಬರ್ 18/10/94 ಪ್ರಕಾರ ಗೋನ್ ಜಾತಿಗೆ ಸೇರಿದವರು 5 ಅಂಶಗಳ ದಾಖಲೆ ಪುರಾವೆಗಳನ್ನು ಸಲ್ಲಿಸುವಂತೆ ಅರ್ಜಿದಾರರಿಗೆ ಹೇಳಲಾಗಿ, ಆದರೆ ಅವರು ಸುದ್ದಿ ಅಂಶಗಳಿಗೆ ಪೂರ್ವವಾಗಿ ಯಾವುದೇ ದಾಖಲೆ ತಮ್ಮಲ್ಲಿ ಇಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆಂದು ಪರಿಗಣಿಸಿ ಸದರಿ ಅರ್ಜಿದಾರರು ಗೋನ್ ಜಾತಿಗೆ ಸೇರದೆ ಪೂರ್ವ ಗುಂಪಿಗೆ ಸೇರಿರುತ್ತಾರೆ ಎಂದು ಈ ಮೊದಲು ನೀಡಿದ ಗೋಂದ್ ಎಸ್ಟಿ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಹಿಂತೆಗೆದುಕೊಳ್ಳುವುದೆಂದು ಸಹ ಕೋರಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರು ಗೋಂದ್ ಜಾತಿಗೆ ಸೇರಿದವರೆಂದು ಈ ವಿಫಲವಾಗಿ ಮತ್ತು ಇವರು ಕುರುಬ ಜಾತಿಗೆ ಸೇರಿದವರೆಂದು ತಿಳಿದು ಬಂದ ಕಾರಣ ಇವರಿಗೆ ಗೋಂದ್ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಹಿಂದಕ್ಕೆ ಪಡೆಯಲಾಗಿದೆ.
ವಾಟ್ ಆರ್ ದಿಸ್ 5 ಅಂಶಗಳು? ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಏನು 5 ಅಂಶಗಳು ಏನು ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು?
Later on, we will also take page 29, annexure D. DC. On this basis, DC also. ಬೇರೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಧೇಯಕದಲ್ಲಿ ತಮ್ಮ ಪತ್ರದ ಮೇರೆಗೆ ನರೇಂದ್ರ ತಂದೆ ಹನುಮಂತಪ್ಪ ವಸತಿ ಗ್ರಾಮ ಕಡೆಗೆ ಈತನ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಪರಿಶೀಲನೆಗಾಗಿ ಸಹಾಯಕ ಆಯುಕ್ತರು ಮಾಡಲಾಗಿದೆ. ಅವರು ಹಿರಿಯ ಅಭ್ಯರ್ಥಿಯು ಜಾತಿ ಪರಿಶೀಲನೆಗಾಗಿ ಈತನನ್ನು ಎಸ್ಟಿ ಗೋಲ್ ಜಾತಿಗೆ ಸೇರಿದವನಾಗಿರದೆ ಇವನು ಕುರುಬ ಜಾತಿಯನ್ನಾಗಿದ್ದು ಎ ಗುಂಪಿಗೆ ಸೇರಿದವನಾಗಿದ್ದಾನೆಂದು ವರದಿಯಲ್ಲಿ ತಿಳಿಸುತ್ತಾರೆ. ಕಾರಣ ಅಭ್ಯರ್ಥಿಯು ಎ ಗುಂಪಿನ ಪ್ರಮಾಣ ಪತ್ರ ಕೊಟ್ಟರೆ ಅದನ್ನು ಜಾತಿ ಪರಿಶೀಲನಾ ಅಧಿಕಾರಿಗಳ ಸಂಸ್ಥೆಗೆ ವರದಿ ಸಲ್ಲಿಸಲಾಗುತ್ತದೆ. ಈ ವಿಷಯ ನಮಗೆ ಮುಂದಕ್ಕೆ ಮುಖ್ಯವಾಗಿ ತಿಳಿಸುತ್ತದೆ. After this, because we did not belong to a so-called notice position. So-called notice connection is placed with then we got the inquiry was made. And in the inquiry, we got five witnesses were examined. The respondent also participated in the inquiry. We got one of the witnesses, Bob. Bhima Shankar, PW5, he was a revenue inspector, Bhalki. He was also examined. He confirms Milord these documents, whereby Milord withdraw that certificate holding that he belongs to Kurva community and not Gold. That was on that day. The order of punishment came to be passed on 6/2/1999. The report, the required report was to find at 21/19 as dated 21/11/97. Page number 7. Analysis of the evidence brought in by officers not at page 80.
80.
80.
Yes.
Considering the entire evidence on the top. Note page at paragraph 8 at page 83 question 70. He has referred to the meeting letter dated 5/5. Deputy Commissioner page paragraph 8 at page 83. Deputy Commissioner either stated in the letter Deputy Commissioner was deputy investigation. Report stating that the person and did not report on the function of the PW5 produced letter. So written by 30 which it is stated that the and conducted the inquiry. During the inquiry, he asked the applicant to give the documents and follow as at the 6th and he could not produce any one of these documents. He did not have any documents that belongs to both. And we recommended to withdraw the certificate to that year. As it has come to know that he belongs to the bottom, the certificate was withdrawn. In this connection, the report dated 6/9/3 made the figure of the price to the as the people to finish. He has stated that the applicant who is the charged with workman was then to the inquiry. And when you were asked to produce the relevant document as per the that he belongs to both, he could not produce the content of the P27 are corroborated by PW5 also produced memo dated 25/3/95 at a 3/28 addressed to substitute workman issued by Proceedings stating that the certificate issued to him was withdrawn. PWC who investigated the matter during January 1990 produced an extract from the admission register of government health and school dated so indicating that he studied in that school and his class recorded as hunger in number 9. He also produced a letter dated 15/12/89 to the superintendent of police either stating that the police minister of the month of charged month of father of Nagi village was verified and he was appointed as police constable in Jesus district police force on 22/5/1949 and retired on 1/2/1985. As per entry made in police station, after mentioned that hunger. She Hananta is the father of Krishna. Dated 21/1/1991 from Deputy Commissioner leader stating that the Mahindra of the proper inquiry reported that his Narendra belong to hunger caste. From the above can be seen that the caste of was defined 2 times by the Commissioner leader in January 91 and again in March. On both occasions, the verification revealed that the certificate workman does not belong to those tribes. And the entry in the state police department is required and the school admission certificate revealed that is not under the state or code. There is nothing contrary to therefore, the inquiry officer holds that he does not belong to those and accept the certificate issue, certificate withdrawing the earlier certificate issued by Proceedings will get on confirmed by. Therefore, we not prior to issuing the charge sheet, when Madhuri Patil's judgment with regard to caste verification by the district committee was not available. This inquiry was done strictly in accordance with 1990 Act. And on that day, we will not go, he did not produce school living certificate or certificate of his caste certificate of his father. Now, the investigation officer in the company has produced those records in the domestic inquiry. And it confirms that he does not belong to one community. It says they belong to Dhanga community. Now, Dhanga admittedly is not part of scheduled tribe community. It's not their case. That's what we want. The management of the respondent from service as per order dated like how long the a dispute was raised. However, an award was passed from 7/11/2008 and we see the award was at page 173. That was the first round, page 173. This award is dated 7/11/2008. So, after considering the entire material of the form, labor code passed an order upholding the order of dismissal on the ground that he does not belong to the community. In view of the certificate issued, withdrawal certificate issued by Proceedings and which is confirmed by the Deputy Commissioner, page 192. Industrial dispute raised by first party husband page, therefore claimed it. Now,
This is the first order.
yes. Now, this was challenged in this petition. Now, in the petition, what was claimed was that another certificate from DC had been produced by the husband before the competent authority, that is the disciplinary authority, which although it was not passed, he did not produce it during the inquiry, domestic inquiry. He said, I have produced it before the disciplinary authority. The disciplinary authority should have considered that would have reversed the position. Now, we are trying to see the order in this. Therefore, for that limited purpose to examine whether that will have any bearing at all. The matter was remanded back. Now that order, you also will find. At page 197, page 197, that is the order. The relevant portion is not mentioned. Page 203, paragraph 10. As this court has now, as this court has now decided to remand the matter to the labor court for enforcement limited purpose, that limited purpose, paragraph 9 before the inquiry officer, as well as to the reasons given by the minister study officer. Review of the document now referred to as communication from the commissioner dated 2 days. The matter therefore requires notification by the labor court, not only with regard to the documents with the additional time to establish its task. Document dated 2 days. But the labor court also will consider the implication of the observation from the labor court. Now, as this court has now decided to remand the matter to the labor court, it is not desirable to go into the next case, though both sides are known as regards this subject. It is suffice to say the labor court should consider the situation now. Communication since the matter is being remanded, commission also then you got the review was filed. Page 2 was filed. Review order page 2 was taken. The liberty of doing labor court to consider on the labor court and therefore directly consider all and then will not be after that the labor court will not often can order on the validity of domestic inquiry at page 209. You also can report that the inquiry has been held in a fair and proper manner. Page 224. Accordingly, I give my finding to issue of the affirmative, holding that the inquiry that is the party is fair and proper. Now, Lord, on merits, we labor court. Because the matter has not, because the first district court verification committee has not considered this and emphasized the civic. So, Lord, the labor court comes to the conclusion that we belong to one community. On what basis? You are trying to see. Page 286, paragraph 32. Considering all facts and circumstances, okay, relating preposition, I am of the definite view that the order passed by the second party against the related to which is not existent is legal. On perusing the dismissal order, it clearly amounts to the dismissal order is passed on the inquiry. This court has already held that the inquiry held in the first party is not so and so. Now, this court has already held that the inquiry held in the first party is regard to classification is illegal and void of admission. Whereas it has not, on the other hand, the commercial inquiry is held affirmative. In view of the other court, there has been one of party. However, this is prior to the constitution of the district classification committee. The labor court has spoken this. Now, Lord, kindly have a look at the document which Lord was brought to notice of this on report in the first count of litigation against the award. Please see, Lord, what is that document? Whether that is a document which validates the earlier certificate issued to me. That document you also will find at page 195. Lord, I disputed this document. Because the matter was remanded back to consider the effect of this document. However, it is not, it is nobody's case that I admitted it. I have said I have not received this document. However, the burden is on the respondent to prove the genuineness of this document having been issued by the competent authority. Anything who has issued it, page 195. It is in my evidence that I have not received it. They produce a copy. Now, Lord, please see, it is not issued by the deputy commissioner. Please see who has signed. If at all it is genuine one. Jilladhikari Kedra Katyari Sahayakaru. So the assistant issues the validity certificate in this manner. Now, Lord, how can this be relied upon to validate the certificate? Please tell me, it has not been issued by the President. And no, the respondent has not examined any witness from the Deputy Commissioner's office to show that this was officially issued and that this has the approval of the Deputy Commissioner. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈಗಾಗಲೇ ಉಲ್ಲೇಖಿತ ಪತ್ರ ಸಂಖ್ಯೆ ಬಸವ ಕಲ್ಯಾಣ ಅವರಿಂದ ಪ್ರತಿಸ್ಪಂದಿಸಲಾಗಿದೆ. ಈ ನರೇಂದ್ರ ವಸಂತಿಗಳನ್ನ ಇದರ ಬಗ್ಗೆ ಪ್ರಪರೇಷನ್ ಮಾಡಿ ಪಂಚನಾಮೆ ದಿನಾಂಕವನ್ನು ಅದು ಮಾಡುತ್ತಾರೆ. ಇವರು ಗೋನ್ ಜಾತಿಗೆ ಸೇರಿದ್ದು ಎಂದು ವರ್ತಿಸುತ್ತಾರೆ. And who has signed? Who signed this? If at all it is signed, if at all it is issued by Deputy Commissioner, it is not Deputy Commissioner. And there is no reference to the 1995 certificate, 93 certificate issued by Tasdikar, cancelled by the Tasdikar in 1995 and subsequently approved by the DC in 1995. Therefore, this can never be a document which can be relied upon to hold that it belongs to government. Therefore, my right to submission to that the award is perverse.
Actually, because the domestic inquiry was held to be proper, certainly because the reference made is wrong.
Yes.
So you are two submissions.
And in view of the subsequent judgments Lord which Supreme Court, Lord, when a person has been appointed on a false caste verification, false caste verification. Now, Lord, the appointment itself is void ab initio. There is no appointment at all. That's what we look at. In fact, there is no requirement for me even to hold domestic inquiry. When I received the certificate in 1995, so pursuant to judgment in Vishwanath Pillai, then subsequently the recent judgment law, there is no requirement for me to hold domestic inquiry also.
So now the subsequent recent judgment alla ಹೇಳ್ಬೇಕಾ ಸುಬ್ರಹ್ಮಣ್ಯ ಗೊತ್ತಾಗಬೇಕು.
Yes, Lord. We have also served it on the Chairman, Managing Director, Food Corporation India and other Food Secretary, Balram Bhajira. Serial number 6824. In fact, Lord, there was an earlier judgment law in Shalini. Where Lord, the Supreme Court taking the sympathetic view on the basis that there was been in Sriya and if no benefit had been taken, it must be clear all that has been reversed. And this is the latest case 24. three judges. So I could find out the point. But page 52, para 24 evaluation.
Page 52, para 24.
Now, Lord, the Supreme Court was referring to the precedent until then. They refer to, and they are not in para 23, they refer to Madhuri. Now in para 24, they refer to Vishnath. The next precedent, which is a relevant from the issue, is the judgment of the three judges spoke in Vishnath. In that case, the appellant who did not belong to a designated other community obtained a card and was elected as the Supreme Court on a seat without a change. However, it was found. Upon a complaint that the appellant did not belong to the and the Supreme Committee the obviously the committee was observed in the report and subsequently the next appellant, CAT, directed that we should not be terminated from this without following the due procedure under Article 311. The High Court reversed the decision that and appellant was dismissed. Before this court, the appellant intervened sought protection since they are rendered 27 years old, rejecting the submission this court held. This court also is this was the appellant obtained appointment in service on the basis that he belonged to scheduled caste community. But it was found that the Supreme Committee that he did not belong to scheduled caste community. Then the very basis of his appointment was taken away. His appointment was no appointment in the eye of law. He cannot claim the right to the post as he had usurped the post meant for a reserve candidate by playing fraud and producing a post. Unless the appellant can lay a claim to the post on the basis of the appointment, he cannot claim constitutional guarantee given an absolutely government. As he has obtained the appointment on the basis of a false certificate, he cannot be considered to be a person who holds the post within the government of India. I think, recorded by the Supreme Committee, that the appellant got the appointment on the basis of a false certificate as a appointment. The position therefore is that the appellant has usurped the post, which should have gone to a member of the issue. In view of the finding recorded by the Supreme Committee and upheld up to this court, he has disqualified himself to hold the post. The appointment was void from its inception. It cannot be said that he said void appointment would enable the appellant to claim that he was holding a good court within any particular field of India. As the appellant has obtained appointment by playing fraud, he cannot be allowed to take advantage of the more fraud in entering service and claim that he was holder of the post entitled to be dealt with under Article 311 India or rules can take where an appointment in a service has been acquired by practicing fraud or deceit, such an appointment is no appointment in the eye of law. And in such a situation, Article 311 of Constitution is not applied. However, 311 was first to say, though the caste certification certificate that certificate of withdrawing the certificate issued earlier has become final, you still have to issue me a charge sheet, board an inquiry, and then go on and then give me protection as a clear, and that was rejected. Then we are. Para 56. the issue, it's a page 61.
Yes.
The issue was revisited in another decision of India in Stalin for during this school. The applicant obtained certificate of belonging to Alpha Scheduled Tribe in July 2004 on the strength of a claim that the Gadwal Postic caste to which she belonged had consanguinity to the Alpha Scheduled Tribe. She was appointed as an assistant teacher and was confirmed in 84. She was promoted as head teacher in 94. This scrutiny committee held that the caste certificate obtained by reference was invalid. A learned in the High Court granted protection in service on the strength of government GR 15695. Thereafter, protracted litigation ensued, which eventually resulted in the judge of the High Court setting aside the order of the investment of the school. This order was confirmed in appeal by the judge. Like Division Bench of the Ninth. Summarizing the position which emerged earlier, decisions of two judges. This court has held. So here, relief was granted on this basis by the school. Can you receive about 7.1? If any person has ordinarily claimed to belong to the scheduled caste of the and has thereby obtained employment, you will be disenfranchised from the schedule. The rigor of which inclusion has been removed only in instances where before the confronted with the case, children were already completed or are on the situations which we stand in case. Where there is some confusion concerning the ability for the scheduled caste thus has issued a word under the guideline of the protection of employment in the belief in the data that we thereafter we test and the thereby removing that in the category of scheduled caste. This benefit accrues from the decision of this court in trade in Raju Ramsing Vasek versus so and so, which was rendered under Article 142 of the Constitution of India. Realizing the likely conclusion to mind even honest person, the resolution for the administration party of state government should share some support to this section. This can be best initiated by citing for the belief that constitutional identified as species or not constitutional, not exactly the way and for the road way, the solution is in last by Shipur, as well as the road. Makes it clear that this protection is available of the so not exclusively or predicated on the mere resolution of this. The High Court in that case, and by rejecting the claim of the applied right upon the decision in however, this court held that decision in Karnataka cannot be constituted to have overruled earlier decisions of 2 days. In that context, this court held. Not the analysis starts with page 72. After referring to the incident, the Supreme Court analyzes the position. Number from there it starts. Page 54. The object is purpose underlying the enactment of state legislation is to regulate the influence of corporate state and illegal instances which have come to light there. Persons who do not belong to the corporate state of just or admissions to the international community. The basic purpose and functioning of the legislation is to explore it and certain elements of the judgment in challenge is respect. These areas including the requirement of dishonest intent into the section 7 and 10 including now. Section 7 provides for cancellation of the certificate where before or after commencement the document does not belong to the judge and is fully currently after employment of the field, then the certificate of employment. These requirements have to be fulfilled before the certificate is done. If also the certificate and the opinion of the physical field of it being voluntarily obtained form the basis of the cancellation order. Section 10 describes that the people does not belong to the activity and secure submission or obtain appointment of the shall upon it application of large and the benefit is not here should be drawn. Subsection 2. Have 56. These are the remaining state, opposite matter and the instrumentality of state. Third, these services are instruments of work where state and law upon the you actually not part of the first available resources and the opportunities provided in the form of public employment are extremely short of money and needs. And the procedure for selection and description of the area has been as a significant positive in enabling the state to make the most appropriate selection of the is a manifestation of the physical area and has delegated effect on good selection of the company much allow someone who is eligible to gain access. Secondly, the right of individual person who is not eligible to support. Thirdly, an illegality is also potential by destroying the rights upon the imposter unlegally. These effects upon good government find a similar report that a person who does not belong to a activity passes off as a member of the education wish to those for whom as a third of state when an imposter who does not belong to the education. If all of the constitution such a consequence must be avoided and stringent steps be taken by the court to ensure that unjust claims of imposters is not protected. In exercise of jurisdiction of the nation cannot live on a line. Courts play a vital instrument to go in preserving the rule. The judicial process should not be allowed to be utilized to protect the unscrupulous and to preserve the benefits which are accrued to an imposter and the patient freedom. Once the legislature has stepped in by enacting Maharashtra Constitution, power under 142 should not be exercised judicially. The Constitution bench in the ring spoke on 28th. The state law has been enforced in the case. Judicial directions must be consistent. Several districts of the state to take notice. The direction with the issue of the there are erroneous, inarticulate remarks that the area was under special reference to Shamini, which Shamini has been over. Now what? Conclusion. You will have to think.
9.
Page 85. The directions which were issued by the Constitution Bench before the Bharat wherein were in pursuit of power section of court under Article 1. Since within of this court in Madhu Party, which was rendered on 294, the regime which held the field in person to full direct then got 69.3. The decision of this court in Vishal Pillai and Muttar, which were rendered by the benches of 3 judges, laid down the principle of law that where a benefit is secured by an individual, such as an appointment or appointment to a post or admission to the special institution on the basis that the candidate belongs to the country for which the benefit is reserved, the invalidation of the certificate or invalidation of the cast of right claim upon verification to result in appointment or as a admission being rendered void, honest. Then we got 69.8. The decision in Kavita Saru case and Shalini of 2 relatives are over.
Yes.
Now, we got the admittedly like we got as on the date when I issued the cash. So we got the admitted district card verification committee had not been put up pursuant to that came in the law. Have a look at it. The act below. In Karnataka, scheduled caste, scheduled tribe, and other backward classes.
Madhuri Patil's decision was dated.
Madhuri Patil. It is dated 2nd September 1994. I have produced that offer.
Date only.
Yes.
For the act. And the amendment happened once.
Good. We also make an section 4, capital A.
To,
A to 2000. For A to D, the incident is A to 2000. It is under 4A that the classification comes in. And the verification under 4B appeal. That was not prior to this. We were to the Tahsildar who had to inquire into, and then we were to go to DC.
where do we get that?
Section. That is not
Which is the provision in that?
Eight to 2000 notification.
8 to 2000 is amendment.
Yeah.
Prior to that, what is the provision? We need the unamended act as on 1994. 1993, 4/5/1993. The problem that we are having.
Normally what they do is they retain the old option.
We need that act, Mr. Kaushal. Subra, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಆಕ್ಟ್ prior to amendment? ನೀವು ಮ್ಯೂಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
ಪುಸ್ತಕ ಈಗ ತರಿಸಿದೆ ನಮ್ಮ
ನೀವು ಇನ್ನ ಲೇಟೆಸ್ಟ್ ತರಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ನಮ್ಮ ಹತ್ರ ನಾನು ಹುಡುಕ್ಬೇಕೀಗ. ನಾನಿರೋದು ಮನೆಯಲ್ಲಿ, ನಮ್ಮ ಆಫೀಸ್ ನಲ್ಲಿ ಹುಡುಕ್ಬೇಕೀಗ.
ನಮ್ಮ ಮನೇನು ಆಫೀಸೇ. After arguing for some time,
Your Lordship may
direct the state government. It's a matter which we are having this problem everywhere. Jagdish ಅವರು ಹತ್ರ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲೂ ಸಿಗಲ್ಲ. After arguing for some time, Pradeep Savkar, the council appearing for the petitioner, seeks for and is granted a week's time to produce the unamended Karnataka scheduled caste, scheduled tribes and other backward classes, bracket reservation of appointment, etc. Act 1990. Read this down. 30th Raja. 25th. We'll have it on 25th.
ಯಾವ್ದು ಸ್ವಾಮಿ? 31st ಗೆ ರಜಾ ಇರ್ಬೇಕಲ್ಲ?
31st ಅಲ್ಲ, 25th. 30th ಅಂತ ಅನ್ಕೊಂಡ್ವಿ, 30th Tuesday ರಜಾ ಇದೆ. 25th ಹಾಕೋಣ, 2:30.
As your Lordship pleases.
This court is coming across several matters where the statutes and or the rules relating to the particular point of time when the point in issue arose are not available. To cite the example in the present matter, what is required is the Karnataka scheduled caste, scheduled tribes and other backward classes, reservation of appointment, etc. Act 1990, as is available on 4/5/1993. Since the certificate in issue was issued on, the certificate in question was issued on 4/5/1993. The bare acts and the commentaries which are available with this court are post the amendment in the year 2008, and the books pertaining to the year 1993 are not available. It is also not expected of the High Court Library to have all the books of the relevant period of time with or without amendments. It would but be required for the Law Department, Government of Karnataka, in association with the Center for E-Governance, with the state of Karnataka, to web host all statutes and subordinate legislation, including rules, notifications, circulars, etc., on the website, on a designated website, thereby collating the statute, the rules, regulations, bylaws, etc., at one single place, and these to be collated chronologically, so that the entire enactment, as that was in force at a particular point of time, could be referred to by any authority, including this, by this court or any authority while dealing with the matter. The learned AGA is directed to bring the above order to the notice of the Secretary, Law Department, and the Principal Secretary, E-Governance Department, to do the needful. A detailed project report in relation thereto to be submitted to this court within a period of 4 weeks from today. Relist on so and so. Other parallel as actor, you what is this circular? Yes, please. No problem. Shekhar or ಕೊಟ್ಟಿದ್ದೀರಾ ನೋಡಿದ್ದೀರಾ ರೆಡಿನಾ ಆಯ್ತು Probation was declared successful yavaga.
89
And declared complete in 2014. Adil agida.
Operation was calculated to be gradually from the date when it was reappointed, 12/7/89. That is date of posting of operation till 36/2014. That is the date of retirement. So the total period was 24 years, 11 months. And paid in gratuity amount of 4,64,198. But after having received this amount, because the respondent was an application before the authority, claiming 2,42,857 again. And the ground saying that the regular service, which is 1/10/1981 till 36/2014. That is the initial appointment which was removed before going back to school. That is another they not declared that we have been service of 32 years, 90 to 19 days, and gradually based
According to your earlier this one, he was appointed on 21/1982. the 11081. What is the significance of 11081? So 2182 ಆಗ್ಬೇಕಾದ್ರು 2182. So that is the date on which the list was prepared. Yes.
Consideration further regarding that, we will open to the parties to work out their rights in the light of the decision of the union in the court in determining 599 to 6 of 1986 disposed of on 26/5/1986. Actually, both those execution order and the respective order. The facts of these restitution are similar to the facts of Governor because the case of following the decision in the open state restitution are allowed. The improved order of termination of partition is directed to reinstate the decision. So, as regarding that, they will be open to the parties to propose their right in the light of the Return number 599 to 6.3 1986 report on 26/5/1986. Now the recovery order in 7. Although the primary question involved in this appeals is on the right of the working to pay holidays and other daily holidays for the purpose of Section 25 of B2 of the Ministry Act. We need not consider that question in view of the recent judgment of the Supreme Court in Governor case. There the Supreme Court has observed that under the rules of natural justice, the body workers are also entitled to notice before their names are deleted from the body. In view of the above decision, Shivan Government Council appearing for the corporation, we rightly submitted before us that the workmen concerned in these fields would be taken to duty, but only should be given to the corporation to determine the backward right of their activity. There cannot be an objection to this submission. It is not necessary to issue the direction of the backward. And the service.
What is the undertaking which relates to backward?
Yeah, backward. But
liberty should be given to the corporation to determine the back wages in light of their understanding. Their understanding between the corporation and the workman.
It's when minority issues framed by the authority. And this is the affidavit filed by the
Except seen and except ಆಗಿದೆ. ಸೇವೆ ಇರಲಿಲ್ಲ ಅಂದರೆ ಸರಿ. But even if reinstated, the reinstatement would date back to the date of the initial appointment. So what does Govindraju's case say? That was only as regards the notice had to be issued and the Badli worker cannot be removed without following the principle of national justice ಅಂತ ಹೇಳಿದ್ರು. ಇನ್ನೇನಾದ್ರು ಹೇಳ್ತಾ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ? Because we accepted that is this issue being dealt with in any other matter, Mr. Sanjay? The probationary period of accept mind. And he has not challenged. The probationary Allah. See, once the Supreme Court declares your termination to be invalid and directs you to reinstate, you give an undertaking that I am going to reinstate subject to my understanding with them. I mean, you prevail upon them to accept your terms, saying that give up your back wages and that. It must have come up earlier also. This kind of a situation must have come up earlier than before this court. So they were at that time, you were in a dominant position at that time. ಅದೇ ಅಂದ್ರೆ ಮುಗೀತು.
Also the order.
Shall be treated as in-service and be paid back.
Treated in service and you paid that another benefit. That I have given back to you. But not consider service and consequences. Expressly granted by the other Supreme Court to go there. Moreover, that is not the case of the response to not they were given up all the right of the
Once the Supreme Court says that your termination is bad and you have to pay the back wages, you cannot misuse that order with the employees and say, ನೀವು ಬ್ಯಾಕ್ ವೇಜಸ್ ಕೊಟ್ಬಿಡಿ ಆಮೇಲೆ ನಾನು ರಿಜಿಸ್ಟ್ರೇಟ್ ಮಾಡ್ತೀನಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಮಾಡಲ್ಲ.
He agrees. Yes, I have put in only. He cannot make a claim.
Mr. Shekhar is fair enough, is what we will have to say. To say I have given up back wages, but give me rest of it and say it. Very back wages. Has he given up the gratuity on that aspect? Nimde draft sari. ತಗೊಂಡಾಗ ಎಲ್ಲ ತಗೊಂಡ್ಬಿಡ್ಬೇಕಾಯ್ತು ಅವ್ರ ಹತ್ರ. Will come with 100 petitions. ಯಾವುದು ಅಂಡರ್ಟೇಕಿಂಗ್?
Judgment rendered by the restoring this position in the Telecast of conductor of 2081 in which you are selected. This statement and Pradeep conductor is posted to them. Therefore, for implementation of Pradeep conductor is allotted between. Further, in his representation, evidence reference and voluntarily given an undertaking to the effect that he is willing to perform that project consequent upon the creation.
Where is that undertaking? Undertaking is a lower debt. Undertaking wordings and ನೀವಿಬ್ರು ಮೆಮರಿಯಿಂದ ಹೇಳ್ತಾ ಇದ್ರ ಅಂಡರ್ಟೇಕಿಂಗ್ ಎಲ್ಲಿ? ಇದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಅದೇ ನೋಡೋಣ, ಅದೇನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಏನ್ ಹೇಳುತ್ತೆ? ಪೇಜ್ ನಂಬರ್ 20th October. Order. Where is the undertaking? Then if there is nothing, then not to produce undertaking. What is the wording for that? If the wording is only restricted to back wages, gratuity it cannot affect because it is Supreme Court says date back to the appointment. No. After arguing for some time, dear Sanjeev, Learned Counsel for the petitioner, seeks for and is granted a week's time to produce the undertaking said to have been given by the respondent to the petitioner. As also, if there are any other matters where similar issues have been decided by this court. Pre-list on 19. 19 or 230 for further hearing. Very back wages under gratuity ಕೊಡಬೇಕು. Undertaking. We'll have to give effect to Supreme Court judgment. ಇನ್ನ ನಿಮ್ ಜಾಸ್ತಿ ಐಡಿಯಾ ಕೊಡೋದು ಬೇಡ. Anyway, you have given up your backyard. ಅದೇ ಡಾಮಿನೆಂಟ್ ಪೊಸಿಷನ್. ಅದೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಅದೇನೋ ಬೇರೆ ಕಥೆ ಆಗಿರೋದು. ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಷ್ಟೇ ಇದ್ರೆ ನಿಮ್ದು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಫಾರ್ಮ್ಯಾಟ್ ನೀವೇ ಮಾಡ್ಕೊಟ್ಟಿರ್ತೀರಾ, ಅದ್ರಲ್ಲಿ ಏನಿದೆಯೋ ಅದೇ ಅವ್ರ ಫಾರ್ಮ್ಯಾಟ್ ನಿಮ್ ಫಾರ್ಮ್ಯಾಟ್ ಅದು ನೋಡಿದಾಗ ಗೊತ್ತಾಗತ್ತೆ. ಇವ್ರ ತಾರೆ KSRTC ತಾರೆ ನೀವು ಮಾಡ್ಕೊಟ್ಟಿದ್ದು ಡ್ರಾಫ್ಟ್. Mr. Krishnan, we got this sketch plan approved. Yes, sir. Good. Yes.
Layout plan. Layout plan, there is no clarity. We'll have to examine once again. The layout plan, the plan rate of land is acquired. Land is not acquired as a nuisance. So it is not.
Where is the property of the petitioner in this? ಬೆಳಗಿಂದ ನಿಮ್ ಫೈಲಲ್ಲೇ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. You could have given it to them. ಇನ್ನ ಎಷ್ಟು ದಿನ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಳ್ಳೋದು ಗೊತ್ತಿಲ್ಲ. 680, 681, 5 you could take it too.
Only the land which have been notified for activity. So probably one of these land might not be known yet.
Where is site number 681?
There must be additions which are made subsequent.
ನಿಮ್ದು ಯಾವ್ದು ಸರ್ವೆ ನಂಬರ್ ಮಿಸ್ಟರ್? 34. ದಿನಮಂಗಲ 153, 151 ಎಲ್ಲ ಇದೆ. SHSS Green Education Institute. Yes. ಎಲ್ಲ ನಂಬರ್ ಇದಾವಲ್ಲ.
On the right side of that, the last one, CH-22, that block notes is what was shown in light blue color notes in the sketch.
ಅರ್ಥ ಆಯ್ತು. ಒಂದೇ ಕ್ವೆಶ್ಚನ್ ಅವ್ರು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕು. ಅಲ್ಲ, you have already shown that number. You are only concerned with where that survey number was there. So survey number 30. ನೀವು ನಿಮ್ಮ ಪ್ಲಾನ್ ಅಲ್ಲೂ ಇಲ್ಲಿ ಶ್ರೀಗಣ ಅಂತ ನೀವು ಸೆಟ್ SHSS Jain Institute of Education Institute. ಅದರ ಪಕ್ಕದಲ್ಲಿ ತೋರಿಸಿದ್ದೀರಾ 651, 652, 653. So the three things to be seen, what we wanted to see was whether it is in the periphery or in the center. It's definitely not in the periphery and not definitely in the center, but it is within the layout. It's not that side aleno madibitru ant kelakagala. That land is situated in your plan, and you have shown sites there. So now that the sites are shown, whether you acquired it or not becomes immaterial. ಇದಾದ್ರೂ ಕೊಡಿ, ಅದಾದ್ರೂ ಕೊಡಿ, ಏನಾದ್ರು ಮಾಡಿ. But you would have expected your authority to be fair enough and come properly. We expect you, we appreciate your fairness, but we expected your authority to be fair enough. The only question we are concerned with BDA as BDA. ಅದ್ರಲ್ಲಿ ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಯಾವ ಆಫೀಸರು ಅದೆಲ್ಲ ನಮ್ಗೆ that is what we are trying to say. Once a citizen comes to you saying that, look, this is what it is, your officer has the audacity to give a report saying that we have used only 4 guntas, we haven't used 7 guntas. ಅದು ಕೊಡಕ್ಕಾಗತ್ತೆ. 7 guntas ಐಡೆಂಟಿಫೈ ಮಾಡಲ್ಲ ಅಂತೀರಾ? ಇನ್ನ ಮಾಡಿ. There will have to be an inquiry made as to what sites were formed, who received the money for these.
What I gather is that those sites have been formed because not probably not.
So how did the BD allow that to happen?
What happens when the land is notified, their record they will not just make us map. So they think, okay, the survey number is not available. And we know that it was part of it, they were planning.
Plan ಮಾಡಿದ್ದೀರಾ?
That is how
we would have agreed to your submission if you have not used even 1 inch of it. Partially you used it.
we have to he was given land. India probably gets more just because it is not the case, we are not taking the lead. The issue is now big. Only the respect of that.
They are known to do that. It's not a first thing. File an affidavit by next week. The council for response files a memo enclosing the layout plan. A schedule of the said layout plan indicates that there are indeed sites which have been formed in survey number 30, which is claimed to be belonging to the petitioner. 35/4. 35/4 elbow actually. 30 idella. Thirty, 31, 35 only they must be.
But in the survey which now they have done, actually those sites are.
No, that won't be proper. Where is 35?
35 is, below 30, there is 33. On the left side of 33, there is 34 and 35.
35 only, there are site number 394, 395, etc. In survey number 35, the indeed sites which have been shown to have been formed. Faced with the above situation, so when a question seeks for and is granted a week's time to obtain instructions and make a submission. We will from 25 each.
Further hearing. What happened to that? ಯಾವಾಗ?
Around 18/4/2022.
18/4/20.
18/4/2022. All 344.
So this is this one. Nice matter. Single judges set aside division bench and other than. Mr. Nitin had challenged it because higher amount was paid as compensation. But state bid ಕೊಡ್ತಾರೆ ಕೊಟ್ಬಿಡ್ರಿ ದುಡ್ಡು.
They are utilizing and they are collecting there are people who have taken this compensation.
When will you place a master? Little further hearing of a previous roster, we can't keep it pending. We would get charity learn special counsel.
That's why I made an application for hardship to measure my land because out of 10 acres, 3,000 hardship. 5 acres, 18 months, they are not specifically notified my land at all. To what extent they are acquired. They are recognized by
Land acquisition, cross abuse and misuse of power ಆಗೋದು ಇದಲ್ಲ. ಎಲ್ಲ ಹಿಂಗೆ ಮಾಡಿರ್ತೀವಿ. Where do people go? You acquired it in 90s and no compensation. They can't use the land also. Land ಅಲ್ಲಿ ಹೋಗಿ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಅಕ್ವೈರ್ ಮಾಡಿದೀವಿ ನೀವೇನು ಮಾಡಂಗಿಲ್ಲ ಅಂತೀರಾ, ದುಡ್ಡು ಕೊಡಲ್ಲ ಅಂತೀರಾ. ದುಡ್ಡು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟರು ಡೇಟ್ ಸರಿಯಾಗಿ ಇದು ಮಾಡಲ್ಲ. This compensation has to be paid on the date on which this order will be passed. We'll shift the date to that. And behind Mr. Mahesha will be another 100 people who will come behind. Very 100 and you will be lucky. ಇವಾಗ ಇನ್ನ ಮುಂದೆ ಹೇಳ್ತೀವಿ ಅವ್ರು ಬೇಡ ಅಂದ್ರೆ ಕೊಟ್ಬಿಡ್ಲಿ. ಎಲ್ಲಿ ಅವ್ರು ಇಲ್ವಲ್ಲ ಮಿಸ್ಟರ್ ನಿತಿನ್? Get those decisions, Mr. Mahesha.
Appearing for respondent in this matter, my lord. Item number 50. Item number 50, my lord.
Unnecessary or inordinate delay. Without a decision, Supreme Court in the when they produce those decisions.
Otherwise, dispute ಅವ್ರಿಗೆ ಇದ್ರೆ only then there is anything, my lord. Unnecessarily. Item number 50 ಅಲ್ಲಿ their entire contention is
47 ಅಲ್ಲಿ ಇದೆ.
I am so sorry, my lord.
Dispute ಬೇರೆ ಇದೆ. Dispute ಅಲ್ಲ. Shri Murugesh, Special Counsel seeks and is granted 10 days time to produce certain additional documents as undertaken on 22/7/2022. We list on 6/9 at 2:30 p.m. Additional ಎಲ್ಲ ಕೊಡಿ ಚೆಕ್ ಮಾಡ್ತಾರೆ.
I appeal for the respondent.
Yes. Mr. Subrao? Ready, Mr. Somshekar?
Yes, madam.
ಬರೀ ಸಿಂಗಲ್ ಬೆಂಚ್ ಕೂತಿದ್ರೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಕೂತಿಲ್ಲ ಅಂತ ಅದಕ್ಕೆ.
ಇಲ್ಲ ಬರ್ತಾ ಇದ್ದಾರೆ, ಸೀನಿಯರ್ ಬರ್ತಾ ಇದ್ದಾರೆ. ಈಸ್ ಇನ್ ದಿ ಅದರ್ ಕೋರ್ಟ್ ಬರ್ತಾರೆ. ಸುಬ್ರಾವ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರೆ ಬರ್ತಾರೆ. ಸುಬ್ರಾವ್ ಎಷ್ಟು
ಅವರು ಇಲ್ಲ. Yes, serial number 48.
I am. Your lordship may do one thing. ಈಗ ಒಂದು ಸ್ವಲ್ಪ ಲೇಟ್ ಆಯ್ತು, ಒಂದು 2:30ಗೆ ಕೊಟ್ಬಿಟ್ರೆ ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೇನೆ.
2:30ಗೆ ಕೊಟ್ಟಿದ್ದು ಬಟ್ ಇವಾಗ ರೀಚ್ ಆಯ್ತು.
2:30ಗೆ ಕೊಟ್ಬಿಟ್ರೆ ತಾವು ಬರ್ತೇನೆ.
48 at the request of counsel for the petitioner, we list on (6/9) at 2:30.
15 6/9
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಎಲ್ಲ ರಜೆಗಳಿದಾವೆ.
ಆಯ್ತು, 6/9ಕ್ಕೆ ಆಗ್ಬೋದು.
6/9
ಹೌದು, ಇವತ್ತೇ ಮಾಡ್ಬೋದು. ನನಗೆ ಅಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಸಿಕ್ಕಾಕೊಂಡಿದ್ದೀನಿ ಅಷ್ಟೇ.
2008 ಮ್ಯಾಟರ್ ಅದು ಮುಗಿಸ್ಬಿಡಿ.
ಇಲ್ಲ ಲಾರ್ಡ್, this is all I am under this weight, Lord, the weight of these cases.
ರೆಡ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ 6th.
ಹೌದೌದೌದು.
ಇವತ್ತು ನಾಯಕ
I do not want to get myself drowned.
Next 49.
Much obliged.
Mr. Sudhakar. ಸುಧಾಕರ್ ಅವರು ಅಲ್ಲಿ ಬಂದಿದಾರ? ಅಲ್ಲಿಲ್ಲ, ರೀತಿಯಲ್ಲಿಲ್ಲ ಅವರು. Forest watches.
Therefore, last 2017, you are required to file an application to give the government as an additional respondent. That is because this matter of only directly to the government take from you. Then I file an application.
Your NPM status ಏನು?
Here is closed.
Closed and has it been wound up? What is the?
Wound up. What happened here? There was the matter was taken before the level. And then the closure proceedings for him. But if I want to make one and here the phone take care of it.
Yes.
Government granting the permission. So I made one immediate challenge that before the level, but they did not pursue that. The only is that other case was very serious law. That is in respect of you, employees, who are sent on deputation to some other government department. There is nothing to do with this project. So the project has the finality, the employees were extended to the and all. But this is nobody can see this project, no activity, nothing activity. What happened, you know, that the entire forest area of not there. But it will never continue. Last 30 years there was. Then there is a scheme, there is an act. There is in respect of in respect of heavy the government, state government, not that some relief to be given. When they are not to be released, I mean, regular, some relief to be given. 2012 ಒಂದು ಕ್ಷೇಮಾಭಿವೃದ್ಧಿ ಅಧಿನಿಯಮ ದಿನಗೂಲಿನ ಕ್ಷೇಮಾಭಿವೃದ್ಧಿ ಅಧಿನಿಯಮ ಆ ಅಧಿನಿಯಮದೊಳಗೆ ನಮ್ಮನ್ನು ಫಾಲೋ ಮಾಡಿತ್ತು 2018 ಒಳಗೆ ಒಂದು ಗವರ್ಮೆಂಟ್ ಒಂದು ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಆದ್ಮೇಲೆ all in work reflect
all 529
what is the way to be there? And earlier, there used to be settlement with the vital government and the delivery workman employed in the point away to the union settlement. 2001 was the last settlement. At 2007 was the last settlement. That expired in 2012. Then the government was instituted in the short for the base case in the part, I mean, on par with the state government delivery of doing the similar, here they are issued a circular in 2008. Then when the government took up the contention to declare there is a settlement with the union. Then whatever terms of the settlement, you are not intended for anything more than that. I think why is the government? Then the government took up this contention also with the objection. The settlement continues. Fortunately, the Lord Vice President India has issued a letter up to 2001 terminating the settlement. Another idea. So settlement terminate. Hereafter we did not find any such government because we are.
So you are a separate union for Forest Employees Association.
Forest Employees that document I have ready. I will know that. I will take it. Now measure the hour of the night. Oh, I was protected.
New ಏನಿದೆ? Minimum wages. New ಏನು? Again, argument ready ಇದೆಯಾ? Chief instruction ಎಷ್ಟು ದಿನದಿಂದ? 2008 matter ಇದೆ. Only 3 things that you have to say. What is the status? What do you intend to do with them? You have continued using their services. They are safeguarding the forest.
And our names are published in the Karnataka. And I have also.
Publish ಆದ್ಮೇಲೆ ಏನು ಹೇಳ್ತೀರಾ ನೀವು?
ಅವ್ರು ಯಾವಾಗ ಪಬ್ಲಿಷ್ ಮಾಡೋದು ಈ ಅಧಿನಿಯಮದಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡೋದು ಪಬ್ಲಿಷ್ ಮಾಡೋದು
ಅಲ್ಲಿ ಅಮೌಂಟ್ಸ್ ಹೇಳಿದಾರ?
Given the copy,
How long do we keep these things pending? Once you recognize them, ಇನ್ನೇನು ಉಳಿತು? You cannot pay minimum wages. You will have to pay them whatever the daily wages which are revised from time to time. It can't be paid at one price only. Matter is 2008. ಇಪ್ಪತ್ತು July, reply memo. Yes.
First document. Second document.
Page 6. ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ವಿಷಯ 2018 ಸಾಲಿಗೆ ಕರ್ನಾಟಕ ದಿನಗೂಲಿ ನೌಕರರ ಕ್ಷೇಮಾಭಿವೃದ್ಧಿ ಅಧಿನಿಯಮ 2018 ಅಡಿಯಲ್ಲಿ ಅಧಿಸೂಚಿಸಲ್ಪಟ್ಟ ದಿನಗೂಲಿ ನೌಕರರ ಎಷ್ಟು ಸಾಲವನ್ನು ಪಾವತಿಸುವ ಬಗ್ಗೆ ಇದು ಇದರೊಳಗೆ ಕಂಡು ರೆಗ್ಯುಲರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು ಹಾಕಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ಅದರೊಳಗೆ ಯಾವ ಮಾಡಿದೆ
20,239. Minimum wages ಎಷ್ಟು ಬರುತ್ತೆ?
ಇದೇ ಮಿನಿಮಮ್ ವೇಜ್ ಇವಾಗ ನನಗೆ ಇದೇ ಮಿನಿಮಮ್ ವೇಜ್ ನಾನು ಕೊಡ್ತಾ ಇರೋದು 12,000.
Now this is notified at 20,239. Near. $15,200. But what is the notified minimum wages? We will leave for this particular government daily wage. Only 20,000 and taxing that. But you made a submission that you are paying the minimum wages. What is the minimum wages? As under the Minimum Wages Act. Otherly Section 20 determination and tax is there. What is the notified amount? ಯಾವ basis ಮೇಲೆ? Whatever from time to time ಏನ್ ರಿವೈಸ್ ಆಯ್ತು, ಯಾವ ರಿವೈಸ್ ಆಯ್ತು ಎಲ್ಲ ಕೊಡ್ಬೇಕು. ನೀವು ಅದು ಕೊಡ್ತಾ ಇರೋದು ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ. ವೆಲ್ಫೇರ್ ಆಕ್ಟ್ ಹೆಂಗ್ ಬರುತ್ತೆ? ವೆಲ್ಫೇರ್ ಆಕ್ಟ್ ಒಂದು ಕೆಲಸ ಮಾಡಿ. The dispute is from which year, Mr. Naik? 18 ಅಲ್ಲ, ಮುಂಚೆ ಯಾವತ್ತಿಂದ ಇರೋದು ನಿಮ್ಮ ಡಿಸ್ಪ್ಯೂಟ್? So 18 ವರೆಗೂ you won't make any claim. So we'll record that, sir. So let affidavit ಹಾಕ್ಬಿಡಿ. So now it has become easier for you. So till 2018, the petitioners are not going to claim, members of the petitioner union are not going to claim anything. 2018, what was the minimum wage fixed? They want that. So what is your stand on that? ಯಾವ್ದಿಂದ ರಿವೈಸ್ ಅಂತ ನೀವು ಒಂದು ಡೇಟ್ ಹೇಳ್ಬೇಕಲ್ಲ, ಅವರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳಕ್ಕೆ.
We are bound by whatever way that we wish to go.
So 2012 ವರೆಗೂ there is no claim. So after that it's
Estimate to translate money document for that. Now my everything now to ensure that one is done.
we'll record your statement, then we'll get it. Shri V.S. Naik, learned counsel for the petitioner, submits that there was a settlement agreement enforced between the petitioner union and the first respondent, which was in force until the year 2012. In terms whereof the necessary wages have been paid to the members of the 31/3/2012. In furtherance whereof the members of the petitioner union have been paid their wages. He submits that post 31/3/2012, the settlement agreement has been terminated on blank, and thereafter the respondents are required to make payment of the wages fixed from time to time. Shri Bojagowda Tipola, appearing for the respondent state, would submit that the minimum wages are being paid to members of the petitioner union. Both the councils are directed to file the respective tabulated statement as regards the amounts fixed as wages in respect of the members of the petitioner union from 1/4/2012 till date. To 8/2016 till date, as in additionally, Mr. Vijaygoda also. He further submits that there was a settlement agreement in force till 2/8/2016. Tabulated statement, as also to produce this settlement stated to be in force from 1/4/2012 till 16/8. Produce what the agreement is. The settlement agreement till 2016 ಎಲ್ಲಿದೆ ಇವಾಗ? So you produce the document to show how it was enforced till 2016. Relist on ಯಾವ್ದು ಕೊಡ್ತೀರಾ? 2008 matter, don't take too much time. Relist on 1/9/2022. It is made clear that no further adjournment would be granted at 2:30 p.m. 50.
Appearing for respondent number 2, my lord.
ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು ಮಿಸ್ಟರ್ ಹಾಕಿದ್ರೆ?
Even this 5 lakhs also may not have got
ರೆಕಾರ್ಡ್ಸ್ had to be secured. ಬಂದಿದ್ಯಾ?
Records have already been
directed to secure and make it available for inspection to both the councils.
Records have already been sent, my lord. Actually, on 13/11/2019, records have been, if I'm right, my lord, 13/11/2019 itself, the records must have been sent.
13/11/19. 7/2022 undertake.
13/11. They have already sent. Other than the Tapal register copy, and actually got it verified. Documents have already come before the High Court, my lord. Not 13/11, but it has already come before the High Court.
ಅಲ್ಲ ನೀವು ಕೊಟ್ಬಿಟ್ಟು ಮತ್ತೆ ವಾಪಸ್ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಇವಾಗ ಎಲ್ಲಿದೆಯಪ್ಪ ರೆಕಾರ್ಡ್ಸ್?
ಅದರಲ್ಲಿ ಏನಿದೆ, my lord, if I may, the only dispute there is whether under section 17 subclause 1, commissioner can pass such an order or not. That is the only dispute, my lord. The entire contention raised by the petitioners is that under 17 subclause 1, the commissioner cannot pass such an order. It should have been before the labor court. Therefore, the order does not stand valid in Teododu is the petitioner's contention. That is all. Nothing else is their contention. It is not at all necessary, Swami.
Counsel for the petitioner and respondent number 2 submit that the records are not required and they will address arguments on the basis of the pleadings filed and documents produced. Aita?
Yes, ma'am.
ನೀವೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ. We list on
any date this week
2022 at 2:30 p.m.
ತುಂಬಾ ಲೇಟ್ ಆಯ್ತು ಸ್ವಾಮಿ ಅದು. Any date before that?
25/8 is 1 week.
ಮುಂಚೆ ಆಗಲ್ಲ. All right, my lord. Much obliged. Much obliged.
We would have heard you today, but we have to go for this swearing in, so ಆಗಲ್ಲ.
Much obliged, my lord. No problem. Thank you, my lord.
ತಿರ್ಗಾ ಏನಾದ್ರು ಕೆಳಗಿನ